choice. Guess we should whisper.
Good afternoon, everyone. There we go. Good afternoon, everyone. My name is Robert Ball, and I'm Chair of the Criminal Justice Commission. I want to start by calling this meeting to order, and I think it would be best if we had the commissioners introduce themselves since there's so many people here today. So starting over here.
Is this on? Now it's on. There we go. Anyway, Dwayne Stark, State Representative for Southern Oregon, House District 4, and it's a pleasure to be here.
And Wally Hicks from Josephine County.
Kiki Parker is Klamath County.
I'm Walt Beglaw, Marion County District Attorney and a Commissioner.
Greg Hezler-Obedian, Lane County.
Rob Levette, Legal Counsel with the Association of Oregon County. And Mike Schmidt, Director of the Criminal Justice Commission staff to this commission.
Thank you, everybody, and welcome. I'll get started. First of all, I appreciate all of you being here. I know some of you are here to talk about some of the programs that the commission may be looking at in the future, and we greatly appreciate you taking the time, especially on a day like this, to come out and talk to us. I'm going to start right away we have a long agenda, so I want to get right into it. And our first item up today is for us to revisit the Oregon administrative rule changes that we're looking at making. So I'm going to turn it over to Ross.
Thank you. So I think Susan's going to queue up a little bit about the Maybe now it's on? Is that better? Okay. So Susan's going to go through the rulemaking process just very briefly, and then I'm going to just kind of go through some of the suggestions that staff has to change the OARs around the Justice Reinvestment Grants, and then we'll go from there.
Good afternoon, everyone. I'm Susan Amesbury. I'm an Assistant Attorney General at the Department of Justice, and I'm contact counsel for the Commission. And I understand that today Ross is going to be presenting some proposed changes to the Justice Reinvestment Program rules. This is just the start of the rulemaking process. What will happen today after the Commission, if the Commission decides, yes, we want to go ahead and move forward with this process after hearing what the staff has proposed, then there will be a formal notice that is given via notice of proposed rulemaking. That notice must be out for at least 49 days to legislators before the rules can be adopted. And there are notices that go out to other parties too. The public receives notice in the Oregon Bulletin. Interested parties receive notice. Folks who have requested notice are on the agency's mailing list receive notice. There's a process that will be gone through. So these rules will not be formally adopted until the Commission receives and considers any public comment that is submitted as a part of that process, and then decides whether any changes to these proposed rules are warranted, and then formally adopts the rules sometime a minimum of 49 days after the notice goes out, but likely longer than that. Any questions from any of you folks? Great.
Okay. Thank you very much. All right. So this being the third biennium of Justice Reinvestment Grants, the first biennium, everybody, the grants were funded at $15 million. It went out to all the counties. Everybody just kind of checked yes or no if they wanted the money. The last biennium, we actually had an application process where you had to, write what you wanted to do in your county, how it was going to address the goals of justice reinvestment. And kind of as we move forward, we wanted to tighten the rules up a little bit and kind of give the commission flexibility. We don't know how much this is going to be funded at yet. We're trying to be responsive to different directions the legislature might go. The governor's budget had this at $32 million, which would be below current service level. So we're trying to, some of these proposed rule changes would be kind of an effort to be flexible around if we were funded at that amount. We've heard people talk about funding justice reinvestment for the full amount for the first year of the biennium, and then the second year would become more competitive. We're not really sure how that would work exactly. So some of this is just an effort to be a little bit more flexible. And then also there's just a few things that we wanted to clean up, this being kind of our, we've been doing this a little bit longer. The way the counties report quarterly, that was something that we worked on a lot, and we think we can do better this time. So we're changing this around a little bit. So we'll go through that in more detail here, but please just jump in with any questions or comments as we go. You should have the OARs here with all the in your packet there with all the additions and subtractions, and then the PowerPoint's just gonna be the same thing. And it'll have the page number as well to help you find it. All right, so the first thing we have is we wanted to add in business days, which you'll see on the next slide. We wanted to go to 60 business days instead of just 60 days. That gives us a little more time for us to work with the counties when their applications come in, for us to kind of give them feedback and try to consider what the grant review committee and the commissioners would want to hear. So 60 business days just gives us a longer period of time than just 60 normal days. And so we needed to add business days to the definition. And this should still, and then we also added in here in the next section in 0050 in the grant application process, which is on page 2. So nothing too exciting there. We still think we should be able to get our intent to award letters out before Thanksgiving. So it'll be the same as last year. And as I think a lot of you are probably aware, you know, when we find out how much the grants are funded at for justice reinvestment at the very end of the legislative session, we try to get the money out as quick as we can to the counties, because a lot of the counties are kind of on hold waiting for that money to keep their programs going. So we don't think that changing this to business days from just normal days should interfere with our ability to do that.
Okay, one question that I had when I read this was that this is any legal holiday. That can be a large number of, and sometimes I've seen them at standards like state holidays, or, you know, there's many different. So I think we may need to clarify that to some degree.
Clarify instead of legal holiday, state holiday.
Some people
or
take
something along
Columbus Day off and others don't.
that? Oh, okay.
As maybe an alternative, because when I crafted these rules, I just basically borrowed your rules from the drug court.
Right.
And so maybe you just go to 90,
Okay.
just so you don't have to define anything. I mean, just go to 90. Maybe.
Okay.
Just an idea.
Another thought might be simply to say court holidays, which I think probably captures the essence of what is meant.
Okay. Sounds good.
Any other commissioners have any comments on that one?
Not to belabor the point, but there is a statutory definition of holidays lurking out there somewhere too, so.
Yeah.
Yeah.
There's that too.
Okay. And do we need to decide which one we're going to go with now, or is that
You do
something
not
we
need to
can-
decide which one you're going to go with now,
Okay.
because we're not adopting the rules today. If the commissioners want to discuss it and kind of come to a consensus, they can, or we can develop these options, look up the statutory definition, that kind of thing, and present you folks with some options when you're actually adopting the rules later on down the line.
Okay, thank you. So essentially, it's just changed from 2 to 3 months in the business days.
Essentially, yeah.
Yeah.
I think it'd be just
Okay.
a little under 3. All right, moving on to the next section. So this is still on page 2, 0060, the grant application review criteria. So in the 15-17 biennium, we had asked counties to tell us how they think they should be measured. We'd asked them for outcome measures, and then a lot of our grant reporting, which is counties are required to do quarterly, was based on that. We ran into some difficulty around that because counties are doing kind of a wide spectrum of things, and there's a lot of counties that are doing similar things, but nobody's doing the exact same thing the same way. So for example, a lot of counties are doing housing. And so when counties asked us about outcome measures, and when they wrote in their applications that they were doing housing, we tried to come up with kind of stock housing questions that we would ask every county that was spending money on housing to answer. But it turns out that in a lot of counties, they might be spending a lot of their community corrections funds on housing already, and they're using this to augment that. And so it didn't make sense for counties to kind of answer the same questions when they were using maybe a small amount of justice reinvestment money on top of their existing housing budget. So we really ran into problems kind of across the board of people being able to report, you know, are we supposed to just report what we used only our justice reinvestment money on? Are we supposed to report all the housing that we bought in this period of time? And asking 36 different counties how they wanted to be measured, not surprisingly, kind of looking at it in the rearview mirror, turned out to be problematic because we got a lot of different things, and it was kind of difficult for us. What we've found getting to the end of the biennium now is that we think we're able to measure how counties are doing with the 4 goals of justice reinvestment fairly well, and that we think we have access to the best data there is to measure the 4 goals. So we can look at prison use, we can look at that for different crime types, we can look at reported crime, we can look at as much information as we have around offender accountability and recidivism, which takes a little bit longer. But we're able to look at all those without really getting this additional information from the county. So we wanted to take out this section, which asks them to give us their outcomes, and we really wanted to kind of streamline the application process around the 4 goals. So we ask questions about how your program will reduce prison use, how it will reduce recidivism, how it will continue to hold offenders accountable, and how it will maintain public safety. So we're going to keep all that, but we wanted to get away from asking them what outcomes they wanted us to measure them by. That also just kind of created a lot of confusion with the counties and was kind of a unnecessary bouncing back and forth that went on for a long time. The next thing we have, which is still in this section, is if you look at the rules, there's a lot that are crossed out on page 3 around the public safety and holding offenders accountable goals. When these rules were written, I think it was before we had any solicitation, and so there's kind of a non-exhaustive list of suggestions around what you could put in for public safety or what you could put in for holding offenders accountable. Now that we're another biennium into this, we think counties have an idea of what they're supposed to be doing around that. And that's also a function that staff can perform and that we can work with the counties if they don't know how to address that part. We've seen successful programs in a lot of counties that we can kind of steer them to. So we don't think that we need to keep that non-exhaustive list of suggestions in there. So we were going to cut that out as well, just to kind of trim down the rules as much as we can.
Okay,
Any comments on it?
before we move on, do any of the commissioners have comments on that?
My only comment is I agree with everything you just said, and I think the reason we plugged in that non-exclusive list was just to start things out.
Right.
But we're way beyond this, so those things just need to come out.
Okay, thank you. And the other thing that I should mention is that we can put those where we think they're useful, we can put those in the solicitation. So people will still be able to see all that information. It just won't kind of clog up the OARs. If you look at the very bottom of this screen on the PowerPoint, the lowercase e, so whether counties will evaluate their programs for increased local costs. So that's a report that's already been done. That's why we're taking that out. And that's something we could certainly look at again if necessary. We just don't think we need it in the rules anymore. So that's why that's being trimmed out. All right, on to the next one. 0070, so the grant application processing. So this and the next slide kind of go together. So this really just gives the grant review committee more flexibility to reject portions of an application that don't meet the goals. So we saw a little bit of this last time. We saw some counties submit applications where most of it was good, but there was one little part of their program that maybe didn't have anything to do with the 4 goals of justice reinvestment, and we wanted to push back against that. So this just gives the grant review committee a little bit more freedom to cut those parts out. And then the part that we might need you to discuss a little bit is that if you look at sub 3 in 0070 on the next slide here, the commission reviews and evaluates the approvals from the grant review committee. So if the grant review committee gets an application and there's part of it that they don't approve, that means it would never get to you all. You guys would not consider that because you're only considering the parts that they do approve. So would like to get some feedback on whether or not you think you want to leave the grant review committee with that kind of screening power and to kind of narrow things down before they get to the commission, or do you want everything to come through to the commission? This is how we had it last time, and I don't think it was really a problem, but if anybody has an opinion about that, please let us know.
Commissioner comments? Questions? Do you keep a record of what you do take out?
Yeah, we can definitely keep that.
I mean, I personally, my only opinion, I always personally like to know if unless it's too exhaustive, but.
Yeah, and it doesn't happen. I think it happened only a couple of applications last time. It happened on some of the victim services part, and it happened, I think, with a couple of, maybe just one county's application. So that's certainly information that we would have and we would be able to provide. It's just kind of where it, who screens it out, who approves it, and who doesn't.
Ross, could you remind me who's on the grant review committee? I know it's defined in here. That membership is a subset of the commission. Is that my recollection, or?
It's I can take a stab at that. It's not a subset of our commissioners. They're appointed by the governor just for that commission, except for Representative Stark just got appointed by the Speaker of the House to be on that commission, along with Representative Williamson. And then there are several members who are no longer in their original positions. For example, the sheriff of Multnomah County has changed since his appointment. There's at least one other person who's no longer in their role, and I'm forgetting who it is. So we need to look at those members and get that to the governor's office to reappoint some new folks.
We've actually got, Susan helpfully has the list here if anybody wants to hear it. So there are 5 members appointed by the governor. So there's a district attorney, a county sheriff, a chief of police, a county commissioner, and then a community corrections director who is not a sheriff. The president of the Senate will appoint 2 non-voting members from the Senate, and then the same thing from the House of Representatives. Oh, yeah. We got the names too if anybody. So last time we had Representative Jennifer Williamson, Senator Brzezinski, Senator Winters, Representative Krieger, Jim Bernard from Clackamas County, County Commissioner, Alex Gardner, who was then the DA of Lane County, Kiki, Stuart Roberts from Pendleton, and Dan Stanton, the Sheriff of Multnomah County at the time. So we have
Thank you.
several that we need to, thank you. Yeah, that we need to touch base on, I think. All right, if there's no further discussion on that. Jump to the supplemental grant period. So this is 0080 on page 4. So this is just a little bit of wordsmithing, really. If unallocated grant funds remain at the conclusion of the acceptance period or become available, this just says that the commission shall establish a supplemental grant period. So it just kind of changes it from if it decides to establish to shall establish. And this allows for some of the changes in the previous section. Oh, you know what? I skipped over a part. I'm sorry. In 0070, there's one other thing that I should have mentioned, which is that the commission would be able to issue provisional one-term grants or one-year grants of a shorter term. So the reason that we think that would be useful is if justice reinvestment were to get funded at a substantially lower level than we're at currently, it might not make sense to give counties kind of the all or nothing option. If we end up with, if we drop down from 38.7 million, which we're in this biennium, to a much lower level, it's possible that some counties would, it might be more appropriate to give them one-year awards. There's also some counties that we know that justice reinvestment has not taken hold in, as well as some of the ones that are doing a lot of good work. So there's definitely situations we could foresee where the commissioners might want to give a one-year provisional grant, and that kind of brings up the possibility that in the second year we might have some extra money floating around if counties had money allocated to them that then they didn't get for the second year. You might have probably not explained that very well, but we kind of wanted to tweak that around that idea so that you would have more flexibility to give 1 year provisionally, and then we would have kind of a mechanism in place for that second year if there's additional money. And then that money would go back into other counties.
Commissioner comments?
Yeah, if memory serves me correct, we've used the one-year award to encourage counties to come within standards that we promulgated for certain programs.
Right.
So this would simply allow us to continue doing that as well, right?
Yeah, that's exactly right. And there's, we try to get all the information we can from counties about what's going well and what's not. And something is kind of, we hear a lot that some things are taking a while to change. And so this would give the commission an opportunity to say, all right, well, you've got another year, and then we'll kind of look at it again, as opposed to we're going to decide the whole biennium right now, yes or no. Yeah.
Sorry.
Thank you. Actually, looking down just below that paragraph, it's number 4. And excuse me, the commission may amend a grant awarded under this rule, and it says after the grant is awarded, the commission may amend the amount originally awarded based on non-compliance. So in terms of having money left over, do the rules accommodate for boosting a grant, amending a grant to boost it to a county that would get some of that leftover money?
So if you had leftover money, could you then give it to a county that had already received full funding? Is that the idea?
Grant, I take it, but this rule number 4 seems to only address counties who are non-compliant. So amending it down, and you don't have to answer on the spot, but I just want to point that out.
Lower on that
as
page.
consideration.
The next section.
Oh, is it?
It's the next.
Reading is fundamental. Okay.
Any other commissioner comments or questions on that particular section? Okay, you want to go down now to the one 0080?
Yes, please. Yeah, so 0080, so that change would, with the possibility of a one-year provisional grant, there's the possibility that later in the biennium, in the second year, there could be funds made available. And then this just changes it to the commission shall establish a supplemental grant period to disperse those funds.
So one question I have about that is if we happen to have money left over and we're going to be making some pretty difficult decisions coming up about potential cuts and how we're going to do that, and looking at automation systems, this essentially to me reads that we shall issue grants instead of being able to use that money for, say, a technology project or an upgrade. And I would be concerned about that because to me it removes flexibility as I read it on the face.
Yeah, I mean, I think that the intent would be to keep the grant funds going out to the counties.
To the grants, okay.
Yeah, and I think that, I mean,
I think arguably that's required
Yeah.
in Article 3194.
I think
Yeah,
that
we were
comes from the
just-
statute.
They
wondering if
appropriate a
it's
certain
statute
amount of money
required.
for that
And
purpose.
we do have some discretion because they're keeping the sum or all of the unallocated funds language baked in there, so.
Yeah.
Okay.
And I think it also gives some flexibility around, if there's a small amount of money left, does it make sense to divide that up 35 ways to all the other counties, or do you want to target that and put it in somewhere where it can actually have an impact? So I think it just says that the commission would need to come up with a process for the supplemental grant period. Okay.
I think we're ready for the next one.
Okay. All right, so jumping to 0130. So this is, again, just kind of a reflection of moving away from the county's performance measures that we would ask them kind of how they would want their program to be measured, and moves us in the direction of streamlining around the 4 goals. So this is just kind of a reflection of what we talked about earlier.
Comments, questions? Okay.
Okay. And 0140, so this really, this is regarding the 3% and the 3% reserved for research. This gives a little bit more flexibility around that 3%. And if the money does come in at a lower level, it would be up to 3%. So the commission would have the discretion to leave more of that money in the county as opposed to taking it for research. So, just trying to be flexible around not really being sure what these grants will be funded at, and kind of have this sorted out in advance. This, I think this might go a little bit, Chair, to your data question, in that if we do, we talk about up to 3% could be used to support randomized controlled trials or outcome evaluations. And I think that gives us some flexibility around possibly, data collection or things like that. I think we don't necessarily want to kind of give the money out and just say, let us know how you would collect your data, and just have it be kind of a blank check in that direction. But this would allow the commission to target that and decide what to do with that money.
Any other comments on these?
I have one comment. So I just want to be clear that if somebody loses their funding in the second year of the biennium, does that also impact the victim's 10% that's coming into that county?
I don't think we have an answer to that yet. I think that's something that the commission would need to determine. There's nothing really on point in the statute or in the rules at this point. So I don't know. I don't have a good answer for you on that. I'm sorry. But I think it would be up to the commissioner's discretion.
Thank you.
Yeah. All right, and as you can see, questions is for some reason lined out, so you can't ask any more questions.
We asked him going through.
Anything else from this part, or?
No, I think, thank you very much.
Thank you very much.
Moving up on our next item is treatment courts research. And will Paul Egbert come up?
Sorry to put you on the spot like that. So, commissioners, what we essentially have, so we thank you for getting through that justice reinvestment rules portion. It's important for us to put that on the record and kick off the formal rulemaking process because of what Susan said and the timelines that are important. So what you have now before you for the rest of today's commission meeting is really all for your information. And so I'll give you just a couple of big asterisks. We're going to talk today a lot about hypothetical funding situations. We as staff have to react to the best possible information we have, and that is basing recommendations and the way we plan things on the governor's recommended budget. And also you'll hear today later on in one of our presentations about potential federal funding impacts. So what today is meant to do is for staff to kind of give you some information on the drug court or the specialty court program. And so that's what we will do. And then we've invited everybody who's in the audience today to kind of also give you their take on how these programs are affecting them in their jurisdictions and what's important to them and what they want you to know from their point of view as you are going to ultimately be going into making decisions about how things are funded. So there is no voting or anything else that's going to take place today. This is for your information to just try to gather as much of the facts as you possibly can, ultimately with the idea that you are going to have to make some decisions. It might be some pretty tough decisions. So hopefully that kind of gives you a big overview, and you should feel free, especially of staff, to ask questions as we go through. And I think that's it.
Is Commissioner Tapia on the phone? I just want to make sure.
Yeah, I'm here. Can you hear me?
Yes, yeah, I just want to make sure you weren't left out if you had a question, so.
Thank you.
Okay. Go ahead, Paul.
All right, thank you. Good afternoon. As most of you probably know, our application period just closed for treatment or specialty courts at the end of March. And so we have our evaluation committee working on those applications. Ahead of awarding in 2015, we gave a similar presentation. At the time, it was 3 slides. I've expanded a little bit, hoping that it would be helpful in terms of understanding what the research says about treatment courts. With that said, I'll tell you a little bit about Dr. Marlowe, but I'm not a lawyer or a trained researcher. And so the extent of what's in here is what Dr. Marlowe put together in a paper he wrote as the verdict on treatment courts. And so he wrote this in 2011 for the Chapman Journal of Criminal Justice, and then he reiterated this same content at the national conference that I was in attendance to in 2014. I found it very helpful in understanding the research around treatment courts or specialty courts. For those that might not be familiar with Doug Marlowe, Dr. Marlowe, he's the Chief of Science, Policy, and Law at the National Association of Drug Court Professionals. He's a senior scientist at the Treatment Research Institute, adjunct professor of psychiatry at the University of Penn School of Medicine. So he's the foremost expert on drug court research and findings. He's to drug courts and research what Bill Belichick is to the NFL coaching profession. So a lot of people rely on him and look to him for what he has to say. What he did here is, because he's trained in law and science, he took an approach of trying to explain how we could understand drug courts relative to the burdens of proof that are in the legal field. And so I realized that I could be subjecting myself to smirks and eye rolling as I talk about some of these thresholds, but bear with me. So he talks about in his paper about the following burdens of proof. Beyond a reasonable doubt, most of us are familiar with these different standards. Clear and convincing evidence, a preponderance of evidence, probable cause, and reasonable suspicion. And what we're going to do is we're going to crosswalk what the research says against these legal standards. And it should help us understand more about what's in the research about drug courts. Just to kind of do the same thing on scientific standards, when we talk about the highest level, we're talking about random control studies, meta-analysis that have good matching, good fidelity, and show with a high level of certainty that it works, above 90%. Clear and convincing, we could look at as quasi-experimental. So there's comparison groups, The likelihood that it's effective is substantial, but it lacks randomness and fidelity and matching, and but we have at least a couple of studies that talk about that. The next level, accepting at least one quasi-experimental study, but it hasn't been replicated. And so you just barely get above 50%. It's likely it'll happen. Less rigorous findings would be the next category. So this is an area where we just need more research because we just don't have enough. And the final one, the lowest one, is we just think it might work based on our experience in the field. So when we match these up, this is the crosswalk of the items here. I won't read those to you again. So what's interesting is this next slide, where it actually takes the drug court types, the most common types of courts out there. There's a whole bunch of problem-solving courts that are in the field, but this is the main court types and the ones that we typically see as applicants. So beyond a reasonable doubt, the adult drug courts are the most heavily researched criminal intervention. There's a lot of research. This certainly meets this threshold. In the clear and convincing evidence, a couple of years ago, DWI and DUI was not there. So I actually made sure and went back with NPC, our consultants for the last several years around our drug court standards, peer reviews, and advisors to us about our treatment and specialty courts. And this has just moved into clear and convincing evidence, this particular court type. So you've got family drug independency, DWI, DUI. If you look at a preponderance of evidence, these are your mental health courts. Talk a little bit more about what some of this could mean. Well, I'll do that now. So essentially, backing up to adult drug courts, the reason it's in that particular threshold is because we know why they work, we know for whom they work, we understand target population, we understand how they work. In clear and convincing evidence, that threshold in family and DWI, we know they work, and now the reason it's moved up there is because there's enough research about the target population. So we know for whom they work. There's still more research that needs to be done to narrow exactly why they're effective and how, and what arena they're most effective. The preponderance of evidence essentially is that we know they work, but we don't have enough research to really flesh out the other details, and including target population. So we should continue to look at mental health courts, and they need more research. In the probable cause area, juvenile courts would fit here. The results are mixed, leaning to juvenile courts being found in many cases to be less effective, and the reason is because they may not be adhering to the model closely, so it's a fidelity issue. So when a juvenile drug court adheres closely to the model, then they're oftentimes found to be effective. And then in this final category of reasonable suspicion, veteran courts, reentry courts, and other problem-solving courts, there's just not enough evidence, research to show that they're effective, and can it's just not sufficient enough to move them up above that point. So like I said, this was this research, or this paper was done in 2011. Dr. Marlowe revisited in 2014, and I know that folks in the field continue to work on this. So I hope that's helpful in terms of kind of understanding how we look at the research in the field in terms of the effectiveness of these different interventions. The drug court model itself is an effective intervention, so the closer it's adhered to, the more likely you're going to have a positive impact. The final slide is simply just for your information about this current biennium and where we have the different courts funded. So if the county is shaded blue, we have funding going to a program in that county. And then you can see what types of courts are funded within those counties. So we have good representation in terms of our grant program. These are not all the treatment specialty courts in Oregon, but represent where we have funding. I did not put a question slide together or cross it out, but are there questions from the commissioners?
Commissioners?
Just a quick comment to add punch to what you just said at the very end, which is this is not the whole universe of specialty treatment courts in Oregon. There's a couple of significant ones that are funded from other sources like domestic violence courts, HOPE as an example, funding from Department of Corrections and other sources. But this is, I think it's just important to note that because these are the ones that we fund, but there are others out there that, and I could certainly hazard a guess at where those other ones fit in terms of your burdens of proof, but I won't do that right now.
Yeah, this is roughly 2/3 of what we consider specialty courts, treatment courts in Oregon.
Other commissioner? comments?
I just would note there's one other burden of proof out there. It's called a mere scintilla, and it's at the bottom of the rung, and I don't want to be in that category, right?
Okay, well, now I have to comment, and at some risk to myself, the mere scintilla standard is the standard by which we introduce legislation. So, I'm sorry,
Things have improved.
So I think as we think about when we meet again the next time, I guess that we'll have to think about these issues if we're deciding, if we're having to make cuts as part of the whole package, so. Okay, thank you.
Thank you.
Next is, our item is State of the Criminal Justice Commission Fiscal Update. And Tiffany Quintero is here to do that. Thank you very much. Welcome.
Hi, thank you. Thank you for having us. And so this is specific to specialty courts. So I don't want you to think that we're talking about the entire budget for justice reinvestment and all other programs as well. So as far as our specialty court grant program, we have some potentially difficult decisions to make. And we thought that it would be good if we kind of went through those in advance and gave you guys all some time to think about that as we go forward. So this year, for the solicitation that just closed, we received 41 applications for a total of approximately $1,600,000. So 22 were adult drug, and if you go down the list on the slides, you'll see kind of where everybody fell out. One thing that's really going to be important to note is that we reduced the rates. So on there you see the rates per day that we'll go through later. I'll show you how we come up with the budget. And the reason that those rates are different is because there's some research out there that shows mental health and family courts are more expensive to fund for various reasons, and I have a couple of those reasons if you're interested. And then veterans and Dewey courts are less expensive to fund than some of the drug courts and the hybrid courts. So that's why the rates are where they're at, and how we figured out the baseline funding. This year, this past biennium that we're just coming to a close on, we did the rates at about $3 more than what they're at currently. And in that, when we did a review for quarter 6, we did notice that many of the courts were coming in underfunded. So we didn't anticipate quite as much of trouble with the rate reductions. However, the reason that we did the rate reduction is because our general fund budget was cut by about 30% for the specialty courts. So if we would have used the rates that we used this 15-17 biennium for the 17-19 biennium, our request would have come in at almost $20 million. The baseline budget formula that we've used is the average number of participants that are served monthly times the number of days in a biennium times the court type. And that gets you to the maximum funding rate that courts can ask for when they request funding through our solicitation. So the only thing that had a cap on it for the 17-19 biennium was a $20,000 cap to the travel and training budget, but everything else they were welcome to use their maximum funding request in any of the categories for as much or as little in any of those areas as they like. Our budget request for specialty courts, when we put in our agency request budget, which is the very first budget request that I believe we put in around September to the governor's office and to the CFO at the Department of Administrative Services, DAS. The general fund request was 13 million. The other funds request was 400,000, and the federal fund request was 1.8 million. The general fund is about in line with where we were this year. The other funds is also about in line, and the federal funds was exactly the same amount as what we funded specialty courts out with CJC dollars this year. And the total amount that we requested is around the same, a little bit more actually, than what we granted for the 15-17 biennium. The governor's budget came back with a decrease to the general fund. However, she did keep the amount of the specialty court special payments, which is the amount that goes out to those courts. She kept that whole at the 15.6 million. The other fund category is our asset forfeiture money that comes in from the counties. That's what goes into that other fund pot. So that's all projected, and the federal fund money is burn jag funds. The impact that this had, like we just talked about, was a $3.5 million decrease to the general fund, increase the other fund by 500,000, and increase the federal fund by $3 million. So that's how that fund shift happened, but it did keep the entire amount whole. One thing to consider is that when we're not getting general fund budget, it's kind of an up in the air hypothetical dollar amount, because our other funds are all projected revenue from asset forfeiture. So it completely depends on how many civil and criminal seizures there are. We get a cut of that goes towards drug courts, and that's the only thing that we can and do spend it on. And then our federal fund revenue, while the burn jag grants are formula based and they have remained steady for the past several years at around $2 million, we have a new president. We are in a different budget state, and we don't exactly know what that is until he releases his formalized budget, I believe in the end of April. And then there's the sanctuary policies and sanctuary designations that are ambiguous statements right now, and I know that there's a plan going forward because we aren't a sanctuary state and the governor's issued her executive order. But if we are designated by the feds as a sanctuary state, or there are counties designated as sanctuary counties, we may face challenges with getting that federal funding right now. So there may be some things that go back and forth, something we're watching very closely, and it makes it so that that money is not necessarily a guaranteed pot of money coming into our office. So the current state of the burn jag grant funds. I had some errors in these numbers before, so I apologize. The one that got sent out was wrong in some of the areas, and so I've marked revised on the couple of slides that I had to change, and I've also updated the handout, and you guys should have a copy of that in front of you, so hopefully it'll be easier to cross-reference. But for specialty courts, the remaining grant funds that we currently have, so we've received from the federal government already in 2014, 2015, 2016. For specialty courts, we have remaining right now that's will go towards the specialty courts, $1,250,000. For other statewide programs, all of those funds are obligated to the variety of things that you'll see in your handout, but they have not yet been spent. They will be spent in the 17-19 biennium, but they are obligated, and that's 1.9 million. And then we have administrative costs left over, and that goes to fund our office over the period of the time that we have the grant. It takes 4 years, or we have 4 years to spend down the JAG funds, so we spread that out over time. Yes, sorry.
So commissioners, you have this handout in front of you. And so when Tiffany is referencing the other statewide programs, if you go below the top chart, which is exactly the same as the slide that you're looking at, and you look below, you can see what you have as commission delegated burn jag funds for out of the 14, 15, and 16 bienniums. So those are programs like the microgrants programs with the Center for Policing Excellence and DPSST, the witness intimidation support program that we've done with the Oregon District Attorneys Association, a victims portal project, a victimization survey, our lipstick staffing around the state program, and we've in the past paid for the Justice Reinvestment Summit out of those funds as well. So those are the kinds of things that we have allocated this money for in the 14, 15, and 16 Burn Jag awards. So just kind of give you that idea.
Yes, Commissioner?
So do the Burn Jag grant funds go through the United States Department of Justice?
Yes.
And if all, not only the $1.9 million, but the $1,248,000 for the specialty courts, those are also obligated. Is that correct?
So we have that obligated to the specialty court grant program because when we requested the grants, that's what we directed it to. However, that money is not obligated to any specific court at this time. So that money will carry forward into the 17-19 biennium as will the 1.9.
Okay.
Helpful.
Mr. Chair, when the time is right, and maybe at the end, I do have a comment I'd like to make for the record with regard to the sanctuary issue.
Okay. Let's go ahead and finish this, and then we'll open it up, I think. And if anybody has any questions, just go along. I spent some time with them on the phone earlier, really trying to figure this out. So I know it's from many different pieces, so we should just jump in if you have questions.
Mr. Chair, I have a question that goes
Sure.
back, Tiffany, to your very second slide, where you talk about applications received and the different day.
Yeah.
And the different day rates that we pay for different types of specialty courts. I'm assuming that the gap between the $7 for Veterans Court versus the $9 a day for drug court is based on an assumption that the VA is providing a certain level of services to plug that gap. Is that right?
That is correct.
Okay. I'm familiar with at least one county where that is not true. Has the staff looked around Oregon to see whether that's a problem widely
So
in Oregon?
we don't have very many vet courts in Oregon. I believe there's
2 or something?
there's
4,
3, maybe
Yeah,
4. So no, I did not. I don't believe we asked all of the courts, but there is some studies that were released that kind of outlined what a vet court costs versus an adult drug court and the others.
So
as
in
well.
the application process, if a county knew that that assumption was not correct in that particular county's case, is there room for that to be transmitted to you or staff?
So there is room for people to have those discussions with us. One thing we did in 15-17 that will, so it leads into our further discussions that we'll have. One thing that we did in 15-17 was we offered a supplemental request. So counties could request supplemental funds if the rate per day did not meet what they needed, you know, because some will have their coordinators won't be paid for by the judicial and others will. Some will have additional treatment costs for MAT and, you know, veterans costs too. So there's all these different things, and because all of our counties are so different, we have tried to come up with a fair way for courts to ask for money, and maybe that's not exactly fair, but we tried our best to set some sort of a rate. And by offering the supplemental request, courts were able to get additional funding to supplement these other programs.
Yeah.
So that's one other thing.
I knew about the supplemental requests. Thank you for reminding me that I knew of that.
Yeah, no problem.
So one question or a clarification, under the governor's budget where it proposes using 4.9 million roughly of federal funding, if we were to go with that budget, that would eliminate funding on the group that's below on the handout, the slide, the the summit and the lipsticks and,
So what that will do is if you look on the FY17, FY18 columns, not the current 14, 15, 16 funding. If you look on the second and third column on the handout, that would eliminate being able to fund any of those programs at all or any other program. So what it will do, if you go with the 4.8 governor's budget, that will take the 1.8 agency request, which is the 1,250,000 that we have right now, and then we have historically requested 300 to 500,000 for specialty courts for the last couple of years. So assuming that we did that again, that's how we got to the 1,893,000 for the agency request. If we move forward and we go with the governor's request budget, that takes the remaining $3 million available for programs in those 17 and 18 JAG funds and throws it all into specialty courts, which leaves no innovative funding and no other target funding for anything.
go ahead. Oh, so yeah, that's what I wanted to highlight to the commissioners, that if we follow the governor's budget, that all of those things below the line for 17 and 18 would not be funded. And that's assuming that we get federal funding.
Right, again,
Right, so
hypothetical
we've got
situation, assuming that
A lot of fun in front of us.
assuming that the governor's request budget comes in where it's at and the legislative adopted budget isn't entirely different, and assuming that we receive our federal funding, that's exactly where we're at.
I would note that this week, the Attorney General Sessions issued what I'll call a policy memo outlining their objectives, and one of them was an expectation that states will align their work with federal expectations through the U.S. Attorney's Office, or the U.S. Attorney's Office and U.S. Department of Justice. So that signal's already come forward, I think. It wasn't specific to burn JAG, but I think it's a start.
Any other questions on the material that she's presented so far? Okay.
So going back to the slide that we were on, this is the breakdown again for the this fiscal year 17 and fiscal year 18 JAG funds. For the other statewide programs, you can see that we've said we would fund some changes to the public safety checklist. We would potentially fund another summit going forward. But the Center for Policing Excellence micro grants are one thing that should definitely be highlighted there as well. So we've kind of broken down the things that we've funded historically and that we would not be able to fund going forward. But that does leave you an unobligated amount that the commission has often used to fund programs that come in at the last minute, such as the Witness Intimidation Support Program that came in last minute last year, and the Victims Portal that came in kind of at the last minute. We had some funding left over, so right before we requested that grant, we were able to work them into the application. So that period will come up in May, and we'll start working on the application, and that's kind of the window of time. So if we obligate all of those funds as requests come in, we would have to turn them away because we would have already obligated everything. Good. So to highlight what we've been talking about, I just wanted to run through very quickly what some of the things that we've funded with Burn JAG in the most recent years are. The Center for Policing Excellence grants are small grants that go to law enforcement leadership students that are working with DPSST and go towards funding small things in their communities that they think that would improve public safety. They've been able to really get that going, and they offer it up, and then they have an approval process themselves. The Witness Intimidation Support Program is funded through ODA. It goes based on the baseline to all of the counties as needed, and that funds victim of crime for emergency needs to be in a safe place while they're participating in a case. The Specialty Court Symposium is the training that we do here in Oregon every 2 years. And we help with that so that our specialty court team members can get there. So we provide some travel and training costs for them to be able to get there. The summit most recently helps us bring all of our public safety stakeholders together. And more than being a benefit to our program, I really think it's a benefit to the entire criminal justice system around our state, because there's not really any other way to get 850 people all together to 1,000 people for 2 whole days. Public safety checklist is one of the assessment tools that's used across the state. Targeted need-based grants, so that's what we were talking about just a little bit ago. We were able to supplement some of these rate requests at the last biennium, 15-17 grants, so that they were able to get more for some of these specialty courts. We also receive requests a lot from different counties to be able to go to trainings or to be able to fund different projects, and we would have to unfortunately turn all of those away. The Victim Services Portal project is something that DOC and Marion County are working on with Codes for America to create a portal that they saw a demo for that we were hoping to be able to maybe expand across the state going forward, but they're working on the pilot to see how that works. The victimization survey is something that's happening in our office. We have some funds allocated to that right now. They're just getting ready to kick it off, so I don't know what that contract will look like for the work that has to be done, but that's a really big lift if anybody's done any research on victimization surveys. And then the specialty court peer review survey processing. So we have the peer reviews that we do, and we have to pay NPC to crosswalk our standards with the responses that team members will give about their specialty court. We pay NPC to process those and give us back a result of what that means, what best practices they're able to meet. So those are all things that we've funded.
So I have a question. So if we funded all of the grants that we've received at the reduced rates, would that then assume we're using all of the burn JAG funds for that 14.5 million, and all of this would not be able to be funded?
So what that will do is that will leave about $1 million of some flexible spending money. The grants came in at a request of almost 14.6. The governor's budget has us in at 15.6. That's about a $1 million gap, and you can assume that that would still be a $1 million gap. So that could be $1 million that you might be able to put into any of these programs or any other program.
Okay.
So very quickly, I just wanted to highlight that the other thing that we've been working on diligently is the case management system for specialty courts. We have been working with OSCIO and procurement and everyone else trying to get a request for proposal out the door for this case management system. But it does have a cost associated with it. So that would be something that all specialty courts in Oregon could use. It would help us be able to, It would help us be able to review and do some research, because we would then have a centralized system. That's not something we've had for a long time since Kelly did her report on the drug courts and CJC worked on that. But again, this has a cost associated with it, and I'm sorry that I don't have a firm number at this time, but we have been working. We've been working to get that. So all I have is an average. We will require a project manager that's going to be approximately $150,000 to be able to implement this for a limited duration position. So this is part of the choices that are before you today. We have the 15.6 that are in the program right now based on the governor's budget. We have a case management system that all specialty courts would really like to have and would be a benefit for about $1,300,000 as an average. That's a guess because we still don't have firm numbers on that. We have other statewide programs that we have historically funded at the 1.2, and then the innovative and targeted needs grants, which is the line item of unobligated funds in the handout that you have of the 1,785,000 basically. So that if you were to keep all of that whole as it is right now and just use the 1.893, the 1,893,000 that we put in the agency request budget, that brings you down to about 12,528,000 that you would have to put into the specialty court program, the competitive grant program.
Yeah.
So I started off this conversation by saying, and I just want to reiterate, I mean, this is what staff's been working off of, and it's our job to try to, structure this program and to get feedback from everybody, commissioners, from the folks who are in the courts. But these are all still very hypothetical numbers. There's a lot of unknowns out there right now. So, like I said, there's the agency request budget, then you get to the governor's requested budget, which is not even going to be the legislatively approved budget. So we still don't know where the legislature is going to end up. But as staff, we have to react to the best information to try to present that to you. And then, of course, we have the federal unknowns in our funding stream. I just want to reiterate that, I mean, these are hypothetical scenarios at this point that we're still working off of, but we wanted to just kind of frame this up for all of you as you will have to start considering, and hopefully as more information comes out, it'll revise some of these things and we'll have more certainty. But for now, just to kind of tee up the conversation and have you be able to ask us questions. Maybe now would be a good time for Rob to talk about it.
Well, just kind of for the record to summarize, I think a lot of people already know. Just talking about the burn jag grants. So a lot of you already know that in the past, Congress has targeted burn jag for cuts for a variety of reasons, political and otherwise. This goes back 10, 20 years. And although they are grants through the Department of Justice, the Office of National Drug Control Policy has a big say in how this is structured and what the president's budget looks like. So I agree, we can't really count on anything right now. It's an unknown. And then the additional unknown is this whole sanctuary complication. Maybe I could just lay out a couple of things which you may or may not already know. So what gets the most media attention seemingly is the fact that Oregon is a so-called sanctuary state. What that means is we have a statute on the books in ORS Chapter 181A, and it's basically been on the books since 1987. It basically says state and local law enforcement in Oregon is prohibited from using its own funds and its own resources to go out and enforce federal immigration law. That doesn't mean that local law enforcement can't cooperate with ICE and other immigration officials, can't work hand in hand with them, share information. It just means that we can't be an arm of the federal government for enforcing immigration law. It's long been my legal opinion that Congress can't force us to do that anyways. That would violate what's known as the anti-commandeering doctrine of the 10th Amendment, and I think that's pretty clear. What is a little less clear is what if Congress decides to condition funding on us being more active, you might say. Or what if the administration takes a congressional appropriation and puts strings on it, such as you shall fill in the blank. Those remain possibly subject to litigation, but in some ways that's a distraction, I think, from what's really going on in Oregon. Because even though that has the media attention, that's not, I believe, because that's so amorphous in what is and what isn't a sanctuary city, state, county. Because I don't think you can use the 181 statute to say we're a pure sanctuary, whatever. We still cooperate and participate. The bigger problem here for Oregon is at least my members, my 36 counties, my sheriffs, are in a box. Because we have an active federal court judgment that's been sustained that basically says, here in our circuit, we cannot legally, constitutionally honor ICE holds. Our sheriffs cannot honor them, and if they honor them, we can be sued for violating the person's constitutional rights, and we have to write a check. We know this because Clackamas County had to write a very big check. So the operative law, according to federal judges in Oregon, is that we can't honor ICE holds. And the current administration seems to be focusing heavily on defining sanctuary or non-sanctuary based on whether or not the local jails honor ICE holds. We can't without writing big checks, so we're in a box. And I'm not expressing any opinion about whether we ought to be doing that or not. We're just in a box. So they can slap a sanctuary label on the 36 counties and somehow try to deny us money, but that's just a real odd situation, and I think it'll just drive us into court to resolve it all. So I just wanted to put that on the record, let people know it's more than choices in Oregon. It's federal court judgments that we're bound by. And I don't know, do you have anything you want to add to that, Walt, or whatever? But
Oh, that's great, Rob.
Any other comments or questions?
Just expanding the discussion a little, going back to our burdens of proof concept here. So I would say that when we, if heaven forbid, we have to start talking in terms of cuts. I would I would really frame that discussion in terms of, do we cut this way and basically cut a percentage out of each of the programs that we've traditionally funded, or do we cut this way and basically say which ones aren't meeting that burden of proof? And so I wanted to introduce that concept to the discussion. If we do have to have it down the line, nobody wants to, but that's kind of my parameter where I would go into that discussion, thinking, do we cut the ones that are existing, or do we cut this way and say, well, if you're not up to the beyond a reasonable doubt or close, then we haven't got the funds.
And if maybe I could add to that, Wally, I agree with you, but I think we also ought to maintain some discretion to look, because, for example, some of the court programs meet a higher burden if their fidelity is up there, and others don't. Veterans courts, for example. So I would want to be able to still have the discretion to say, no, that particular court program is really well performing, even though it's one of the other ones. You know what I'm saying?
I do it.
Yeah.
Sure enough. Yeah, I get it. And even going further, so back to our first slide of the dollars per day, the 9 versus 13. So we may end up needing some more hardcore data on that from the commission to find out if we're getting our bang for the buck, and put that into the discussion as well.
I agree. One of the other things, I don't know if it's highlighted very clearly here, is productivity. And are there some courts that just are not performing? And what does that mean in their sheer numbers versus other courts that are performing?
Okay.
And looking at that as part of the discussion. Those are very difficult looks, but.
So I just add, the process that we're in right now is the applications have been submitted to us, and that period is closed. And we have a panel of expert reviewers who are going through all those applications and are scoring those as we speak. And so that'll be another layer of information that when you as commissioners are trying to look at high performance in courts, we'll have those expert panelists who are reviewing the applications to give you some more information about specific courts as opposed to just broad categories.
Great.
Mr. Chair.
Commissioner?
Yes, I appreciate all the comments, kind of planting the seeds about what we're going to need to analyze here. We've been through this before, and having been on the commission for a while now, and in other areas where we were kind of working our way through the recession and delivering public services. And I just recall thinking very carefully about where are our core services, and are we having direct impact on individual lives in our courthouses? And I just always remember being drawn back to that when making hard choices and comparing it against innovation, entrepreneurial thinking, all great stuff. But when you get down to it and we have less money, I was always looking into the courtroom. Are we changing lives? And so I know that was helpful for me working my way through some of those decision points. But that's kind of where my mind is starting this thought process.
Commissioner?
Yeah, I couldn't agree with Commissioner Beglaw more, and that's why I was very happy in staff's presentation that Tiffany just led us through, that the optional things were the things not described by Walt. In other words, that the specialty courts actually giving services to people in need were considered the core mission of those dollars and of this commission, and the other things were on on a different page. And so I think it's good that staff is in line with at least what two commissioners think.
I had a question about the lip sticks. I'll get to you, Commissioner Hicks, just a sec. We got a federal fund, right, for the coordinators of those, is that correct?
Yes.
Is that included in that?
No, so we applied for a grant that was $1,750,000. We received half of that. And because it was difficult to do the entire program, when we talked to the commission last year, and we knew that we were going to be only halfway funded through that federal justice reinvestment grant that funded the lipsticks, we requested the additional $1 million to be able to fully fund that program. So that fully funded the lipstick program as outlined in the application for the justice reinvestment lipstick grant.
So my question is, what is that $1 million that's below the line on this?
Oh, I'm sorry, that is the amount that is contracted with the $875,000. I thought you were asking if the justice reinvestment lipstick grant itself was part of that.
Okay.
Sorry, my misunderstanding.
Commissioner Hicks?
Thank you, yeah. So picking up a little bit on Commissioner Biglaw's thread, I mean, looking at this slide of what would be on the block, I see victim portal project, victimization survey, and it reminds me that a lot of victim services grants in general are funded through the United States Department of Justice. And so to the extent that the DA's office or the DA's offices of Oregon would be impacted by cuts by the United States Department of Justice, we wouldn't necessarily see, I would think, a lot of line prosecutors getting affected, but it would be entire programs like the victim services programs within certain offices. And so it's like, well, are we going to be a state that doesn't have victim services anymore? Because that's a little bit of a core function to Oregon's approach to justice right now, and justifiably so. And victims, I believe, have rights as enshrined in Oregon law in many places. And so, we might have to expand. I don't know. We might have to expand our thinking to fill in a little bit of that gap if the victim services program in Oregon gets effectively eliminated due to its dependency on these federal funds. So it's a little bit dire to discuss that, but we need to think about it right now.
Mr. Chair, I think the other thing that we need to think about too is the impact of the Affordable Care Act and paying for treatment services as we start looking at. In certain counties, they only fund a portion of the drug court coordinator or something else, and if we have reductions in the ACA, then obviously that's going to impact the ability for our folks to get treatment services. So I think as we start looking at this, we really should look at the big picture and all of the federal impacts that could come to us here in Oregon.
That's a good point. Any other discussion points at this time? Okay. Mike, go ahead and get your update.
Tiffany had a few more slides, but I think we've had that conversation, so it's probably good to just jump forward at this point. So the only thing I would say, and Tiffany brought this up in her presentation, was just an update around our OTCMS, or OCTMS as it's written there, which is our drug court data system. This is something that has existed previously, but at this point it's gotten so old and decrepit that it doesn't function anymore in any of our courts. We don't have a unified data system any longer, and some courts are still running it. And some courts aren't. Some courts are keeping data and keeping track of records and things by Excel spreadsheet or other means. And some courts have come to us and asked and have discussed maybe going out and procuring their own data systems. So the idea was when we weren't facing these dire budgetary constraints, was that staff would go out and try to price and find out how much it would take to get a uniform statewide drug court data system that would be available to all drug courts or all treatment courts across the state, both so that they could use it as the system, but having one uniform system in Oregon, of course, allows us to be able to do better research, to be better integrated, and talking about what works and if the funding decisions that we're making, are we getting the bang for our buck? All of those things are so much better when we don't have, 15, 20, 30 different systems that are springing up all across the state. So we are very much in the process right now of working through the RFP. We are at the Department of Justice finalizing the language for that RFP to get sent out so that we can have some firm numbers on what those costs are. Tiffany presented some of the estimates that we've seen. We're anticipating to procure the product and to get it implemented in the next biennium and up and running. It'll probably be at least around $1 million to do that. So it's, again, one of those things, you know, it's a smart investment because it helps us make sure that the investments we're making are effective. It also helps our drug courts in the work that they do, that they have a system that's uniform across the state that they can use for working on their different projects. But at the same time, it's another discretionary amount of money that would have to be balanced against all the other tough decisions that are facing all of you. So I just wanted to give you the timeline. I anticipate that before we are making these decisions, hopefully, or possibly not, but I'm hoping to get you some final numbers on what it would be to actually go out and buy that system so that you can have that in your decision making when we go forward.
Just one thing. I wanted to also, I was remiss not thanking you, Tiffany, for your presentation. So thank you very much. It was great. Commissioner
Thank
Hayes.
you for indulging me, Mr. Chair. Okay, a little bit of a it's on topic, but it's coming from a unique place. So thinking about the, but I assure you, and you'll know where I'm going with this in about a minute. All right, and okay, thinking of the people who run these specialty courts. Okay, the judges, the staff, they tend to be senior people within the Oregon Judicial Department. I mean, these people are there largely, I mean, they could be eligible to retire, a lot of them. And they don't, they stay on because they love what they do. So I wanted to ask maybe some of our insiders, what is the status of PERS reform? Because some of these folks, quite honestly, might hang it up after this legislative session. The people who actually have this institutional knowledge that we depend on, I mean, thoroughly depend on to make these specialty courts work. If PERS reform gets them spooked, you know, we could see a real problem. So do you have any insight on that?
Okay, well, and I'll defer to the representative as well, but we have a lot of people spooked about PERS reform. Here's why I don't think they should be spooked, and then why they may be concerned, but not spooked. Why they shouldn't be spooked is we have clear guidance from the Oregon Supreme Court now with the Morrow decision. There is really no way to strip Tier 1 and Tier 2 folks of their accrued benefits. And if we have to change things moving forward, we essentially have to create a split system. So the bottom line is, I really don't see a pathway to PERS reform that is 1, constitutional, 2, actuarially sound, 3, amounts to a hill of beans, and should cause people to get spooked and leave. Now, that does not mean that it's not possible to do PERS reform that essentially takes existing Tier 1 and Tier 2 people and give them a lower level of benefit, but only from their moving forward time. So there wouldn't be any reason to drive them out of the system. It's just they may experience 2 tiers of benefits, everything they got now and then maybe a lower tier later. If you get me into it any deeper, it's going to get complex and you'll roll your eyes. But basically the Senate Workforce Committee has been working pretty heavily on this. Senator Knope in particular, and he's got a variety of ideas about how we can actually save money in the system moving forward. But none of those things really should spook anybody, in my humble opinion, any of the things that have a chance of moving. But that's my 2 cents worth, but maybe.
And I'm no help on this whatsoever. I have not been in on any of the PERS reforms conversations.
Congratulations.
Yeah, lucky you.
These conversations, yes. But.
Okay, we're ready to move on, unless there's any other questions or comments. Our next item is the RFP review timeline, and Chris Thomas will be updating us.
Yeah, where are we in the process?
So the applications, we have the panel reviewers are coming together on the 10th. We will be discussing applications and the scoring at that time. And then we will be putting that information together for a package for the commission to discuss.
Okay.
So, yeah, just to, we're currently in the review of the packages, everything that's been submitted from the courts. So our expert panel is reviewing those right now. They'll have scores. Staff will bundle that, and then we'll have that information for you all when we schedule our next commission meeting.
Okay, thank you.
Come.
Our next item is our public testimony, and we have a sign-in sheet. And first up is James Tierney with Wayne County District Attorney's Office. After James will be Robert Juber and Danielle Form. Oh, Danielle Farr. Go ahead and have a seat at the microphone so the people behind you can hear you as well.
I was asking to yield the floor to Robert Jubber. It would actually be helpful to our presentation.
Sure.
Robert Jubber is a recent graduate of the Lane County Drug Courts, and he's here to speak on.
Great. Welcome, Robert. And when you look down, there's a button. Make sure the blue light is on.
Okay, good. There we go. Thank you for the opportunity. I want to start this off to just imagine, if you will, that you're on your way to work. Whatever route that you normally take, whatever alleyway you drive past, whatever intersection that you always hit that damn red light at, that you notice that one person. And this person seems familiar to you only because you see them on a regular basis. Maybe you wonder what their name is. Maybe you're curious as to what their story might be. Or if you're like me, maybe you always plan on stopping, offering some food, but never do. Whatever the case may be, all you really know is them digging through a dumpster. Maybe they're holding a sign that says anything helps, God bless. Or they're towing a trailer full of cans with a busted bicycle. But I'm actually here to give a name to that person and a glimpse into that person's story. 2 years ago, that person was me. My name is Robert Jubber, and I was homeless. I had a very demanding drug habit, and it took me to some very, very dark places. The people that I considered friends weren't to be trusted. I found myself alone. I found myself isolated. I found myself hopeless and so infected with shame that I actually, honestly considered myself subhuman. Not to mention, I had arrest warrants because I was absconding from drug court. I knew I needed help, but I had absolutely no idea how to get it. Nor did I feel that I ever deserved it. I honestly thought I should have stayed that way because of what I had done. The only solution I actually could come up with in my head was to run away. So I decided to start walking down I-5 from Eugene, and I was just going to go south. 3 days later, I ended up face down from exhaustion, praying for death that a semi would actually blow a tire, jackknife the trailer, and run me over. Instead, my mom saw me. She was driving by. She stopped. I got in. I remember her rolling my window down because I didn't smell all that well. And she took me home. I got cleaned up, but that arrest warrant was still haunting me, and it eventually got me. I was brought back to drug court, and the team there in Lane County was left with a decision to make. They were either to terminate me, or they were going to let me continue. And going against some of the team's recommendations, they decided to let me stay. And again, that was 2 years ago. But the journey from there was not easy by any means. I still had a lot of fight. I think I pretty much fought every step of the way. I even had an argument as to why I should continue to use and still advance in the program. And I'm pretty sure that's when they decided to send me to inpatient treatment. But while I was an inpatient, something clicked. I'm pretty sure that was the turning point in my life. I started to realize that I am a valid human being, I do have a story to tell, and I do have the ability to make better choices. I also realized I have a place in this world, a place in the community, and a place in my family. Needless to say, the road to completing the program in drug court got a whole lot less bumpy. But since my graduation last August, I've helped launch the Lane Treatment Court Alumni Association, and this is a nonprofit organization for alumni of Lane County Drug Court that focuses on having peer-led pro-social activities so that current participants can see that recovery isn't really all that dull or boring. We've also put together a drug court softball team for the first time in Lane County. My life has just, I actually have a life, to be honest. And if it wasn't for drug court and the resources that they have allowed me to partake in, none of it would have been possible. I probably would have been dead somewhere, probably on a freeway somewhere, I don't know, in Nevada somewhere. But they offered me a chance at a new life. They really did. And so I come here today speaking to the people who provide resources to those treatment courts, not only Lane County, but in Oregon, everywhere. I really urge you to consider what treatment court does from not only myself as an individual, but also the community that I live in and the community that these individuals live in as well. Lane County Treatment Court alone has over 120 participants, all of which have a story similar to mine. So when the time comes that can-toting, busted bike-riding bum finds themselves face down on a freeway praying for death, either literally or figuratively, I would love to see treatment court be able to offer them a chance at a new life like they have me. And thank you for your time today.
Thank you, Robert. James, do you want to come back up?
Good afternoon, Good afternoon, Commissioners. My name is James Tierney. I am the Lane County Assistant District Attorney who is in charge of the Drug Court, Veterans Court, and the Mental Health Court. I am also the District Attorney Representative for the Oregon Association of Drug Court Professionals. So I come to speak on behalf of both of those entities. Firstly, with Lane County, as Mr. Jubber stated, that story is all too common. The opioid epidemic has hit Lane County like no other. Over the past year, I have filed 1,000 unlawful possession of controlled substance related cases, and all of those cases are medium to high risk. These individuals play a large role of Lane County's problems, and we are doing everything we can to give them some sort of treatment. Their impact to our community impacts the entire state. And I say that because with the opioid epidemic, you need money in order to buy heroin. In order to do that, you must steal something. When you steal something, you're hurting the community. And once you do that, you'll receive a conviction that is subject to Measure 57. The next step there is, after a couple of those convictions, you're now looking at prison time pursuant to that statute. One of our primary goals in our treatment courts is to avoid that. So we are attacking these young individuals who are medium to high risk that come across my desk every morning. And you might think that this is a sporadic type thing, but each week I receive 20 intakes just for heroin and methamphetamine cases. And the numbers that are coming through are astronomical. We have a number of challenges, and that is to continue to provide medically assisted treatment to these individuals, Vivitrol and Suboxone, to try to give them housing, to try to change their life. And it is something that we tackle every day. And this is not only for drug court. We have these same individuals who are in mental health court and veterans court, approximately 160 people in our total specialty court realm. So I urge the Commission to be cognizant of the fact that these specialty courts play a huge role in communities such as Eugene and Coburg and Cottage Grove, Oak Ridge, and those surrounding areas. These individuals who, like Mr. Jubber, were at the side of the road are now positive and pro-social members who have a GED, who have a job, and who have graduated. I've been the Assistant District Attorney for Lane County in this realm for 18 months, and we must have graduated 60 to 80 people. Ms. Hanson will be able to talk about that a little further. But these individuals must have a job or GED. They must have a pro-social life before they can graduate, and they're turning around their lives, which in effect is helping our community and reducing what could be a higher prison population. As the Oregon Association of Drug Court Professionals, we are cognizant of these concerns, these funding concerns, and our administration is doing everything it can to assert our presence to recommend that all counties try to seek funding elsewhere. And I'm not sure if Ms. Thomas mentioned it, but there were 8 more applications this year than there was last year. So there is a much higher role, and drug courts are playing a larger role in these communities. And I'm not sure if the panel has gone to any of these National Association of Drug Court Professionals, but one example of evidence that I find to be so striking is that if you get into drug court and you successfully graduate, the research shows that 99% of those individuals never see a courtroom again. So if I can get my hand on someone and I can get them into the program and they graduate, they don't come back. Even if they don't graduate, they lower to 75%. 75% of those individuals do not come back into the courtroom. So I urge the commission to deeply understand how much treatment courts play a role in Lane County, and as the Oregon Association's representative, drug court professionals representative, how much they play a role in our state. Thank you for your time.
Thank you. I have a question.
Yes,
so, as we're considering the cuts, and any other presenters that come up, if they have a thought about this question, when we reduce the funding from so many dollars, $12 to $7 a day, what does that actually mean on the ground in terms of how are you dealing with that actually in the courts?
As the district attorney side, I have to defer to Ms. Hanson, who will speak about that. She's our coordinator, and she would have a little more information about that.
Okay.
That does affect my position. I am funded via our grants so that I can continue to pursue possession cases as stated. Thank you very much for your time.
Can I ask him one?
Oh, yeah.
Thank you,
Commissioner
Mr. Chair.
Good
So,
afternoon.
and how you doing?
How you doing, Mr. Hicks?
I'm doing
Nice to see you
well,
again.
so nice to see you also. Okay, thinking about alternative funding source possibilities for drug courts, which none of us want to have to think about, but it may come to that. So, as you may know, a lot of counties in New York and West Virginia, and most recently the city of Everett, Washington, are suing Big Pharma for its approach to opioid overprescription. And you know, I don't know what's going to happen in Oregon, if anything, but if someone were to come to either you, Mr. Tierney, or would it be possible for you to actually compile somehow the numbers that would represent the opioid epidemic and the growth in recent years? Like if someone from OHA or the Justice Department or even the commission here were to ask you, so what are the exact numbers? What could we actually show Big Pharma, the actual impact of its overprescription of opioids and its abusive practices? Because if someone were to sue, which is going on in other parts of the country, and sort of divert perhaps any recovery of that into drug court programs, you know, we need to start by demonstrating actual damages. And so I don't want to put you on the spot by any means, but I want to maybe plant that idea that if you have any kind of a database system, is that even remotely a possibility to put a number on that?
Yes, I'm positive our office could do that.
Okay, thanks.
With the heroin numbers from 2017 all the way going back, we have, most of the DA's offices have something called prosecutor by carpel, and they're able to track those type of things.
Okay, so I mean, just Big Pharma's on the ropes a little bit right now in terms of the plaintiff's bar.
I was just going to say, we have a commission member who knows how to challenge Big Pharma, Mr. Bovet.
Yeah, and I'm really reluctant to go off on a soapbox right now, but I'm really tempted.
I understand.
I mean, all you have to do is Google my name on Oregon Live, just showing. This has been a hot issue for me that I've been fighting for most of my career. The short story is that 2 generations of doctors ago would never have prescribed opiates to treat non-cancer chronic pain because they believed and were trained that the use of those drugs would create addiction in their patients and was not effective long term. And through pseudoscience, the pharmaceutical industry basically took that down wrongly, and they have paid the largest fines levied in the United States history as a result of that pseudoscience. We've taken down that pseudoscience, but now we have a culture that expects all pain to be treated, and often treated with opiates, which feeds into the opiate addiction problem. I don't know what the statistics are in Lane County, but up in Multnomah County, about half of the people that are hooked on heroin in Portland started out popping pills. And in other areas, it's even more significant. I would echo what you said. I had the privilege, if I look back on my time in Lincoln County, the 4 things I'm probably the most proud of are starting our drug court, our HOPE program, our mental health court, and our DV program. And those are all evidence-based stuff, but I will tell you from my anecdotal experience, and I have no science to base this on, getting heroin addicts off heroin is a real challenge. And if you can get them to graduate, I agree with you, we don't see them back. But getting them either titrated down to something we can manage or off entirely is a real challenge. And sometimes it can be real frustrating, but it's a worthy adventure. In terms of going after the pharmaceutical industry, they're no longer touting that pseudoscience, but the damage has been done, and we're still dealing with the fallout. And I could go off on an hour-long soapbox, but I'll stop right there.
Thank you. Any other comments? Okay, thank you.
Thank you very much.
Next up, we have Danielle Farr. Then after Danielle will be Lane Borg and Nancy Kozine.
My name is David Leith. I'm a Marion County Circuit Judge. Danielle Farr is here. She was going to testify together with the Marion County group that's later on your list. Dick Cowan,
Maybe we could take those two.
Loria Evans,
Okay,
David Leith. If we could defer Ms. Farr and then bring that group up all together.
Great.
Thank you very much.
Let's have Lane Borg and Nancy Kozine come up first, and we'll do the entire group. And could you introduce yourselves to the...
Yes, good afternoon, Commission members. Nancy Kozine, I'm the Executive Director at the Office of Public Defense Services. And I would thank you for having us here today. Do you want to take a minute to introduce yourself, or do you want to do that?
Sure. Commissioners, my name is Lane Borg. I'm the Executive Director of Metropolitan Public Defenders. For those of you not familiar with Metropolitan Public Defenders, we're a nonprofit, private. We're the largest public defender's office in the state of Oregon, and we have our primary offices are in Multnomah County and Washington County.
So I wanted to start by thanking you for the work that you do. You bring transparency, curiosity, and integrity to our criminal justice process. And I think all of us in Oregon are incredibly grateful for that work. Additionally, I want to thank you for the 2017 summit. It was amazing. I've told Director Schmidt how much our office appreciated it. We sent all 4 of our contract analysts. They were inspired, not just about their own work, but also about what's happening around the state in terms of looking at criminal justice and opportunities to improve it. They have committed to trying to work with the new LIPSIC coordinators so that they can be a part of conversations around improving outcomes in criminal justice around the state. So, that said, we're here today with a request, and it's probably an ongoing request, regarding grant funding and the analysis that you give to that process. The request really is to, when you look at those grant applications, to look at whether or not the grant is a balanced approach. So oftentimes what we see is that counties do not include the defense providers in the grant process. Some of you know that in Multnomah County, it actually is really, the defense is very consistently considered and included in the discussions. Around the state, we see a large variety of practices and a varying amount of participation, really. The backdrop, though, and I want to acknowledge that we have a very difficult budget environment, and so I'm making this request potentially at a difficult time. But the backdrop is that the Public Defense Services Commission, which is the entity responsible for ensuring that everyone has representation across the state, in assuming they're financially eligible, and the case is a case in which there is a statutory or constitutional right to counsel. The commission meets that obligation through a contracting process. The contracting process is an RFP process. We'll put that out in May of this year. Contracts begin in January of even years, and they go through December of the odd years. So the current contracting cycle started in January of 2016. It will end in December of 2017. A couple of things happen when a defender isn't included in the grant process. One is that ultimately the funding has to come out of our system, and we're not always aware that a new program is starting up, especially if the defender hasn't been included in the conversation. When that happens, typically the way that we pay for a case is we pay a flat rate for all services at the front end of that case. So if it's a C felony case, there's a C felony rate, and that's what's provided. If there are subsequent hearings after the initial disposition, we would pay additional rates, potentially like for a show cause or a probation violation hearing. But that model can get very expensive, and it doesn't ensure consistency for a drug court program. It's whatever attorney is assigned to the case. So the way we worked it in many counties is we try to ensure that one lawyer will be present for a drug court program so that there is consistency. But again, we don't always know that that cost is coming if we haven't been built into the discussions on the front end. Additionally, we don't always have the funding available to cover that cost. So in this biennium, for example, we are about $13 million short of the original of the amount we originally contracted for because of the skyrocketing caseload that we're seeing across the state. In this particular instance that Lane will talk about, you know, what's happening is that the grant cycle isn't coordinating with our contracting cycle. And so there's actually an unmet need for the start of the biennium, but it's just the last 6 months of our contracting cycle. So I think it's a twofold request. But as you look at these, and maybe in the future, think about establishing criteria that either encourages or requires a balanced approach to the prosecution and the defense functions in your specialty courts. And I think that that's for two reasons. One, it's a legitimate and reasonable way to approach the funding problem. It also really sends a message that the Criminal Justice Commission is committed to having a balanced public safety system. So that is my request for you today. And again, I sincerely appreciate all of the work that you do. Thank you.
Thank you, Mr. Borg.
Thank you. And I want to expand a little bit on my office, and thank you also. My office has been the beneficiary directly of grant funding through CJC. I also am the defense policy team participant in the MCJRP program in Multnomah County that is our Justice Reinvestment grant response that has, I think, Rod Underhill claims, and I think he's right, has legitimately saved the state like $20 million in the biennium through our efforts. And so that hard work has really paid off. What I want to talk about, though, specifically is in response and in support of Nancy Cozine's request, is that, you know, in preparation to come here, I decided I should do what happened to me one time when I was in your position sitting as a commissioner. I looked on your website and I looked at your mission statement. And your mission statement really speaks to being innovative, changing, looking at ways to improve and do things better. And that's great, and you should be doing it. I've always looked to CJC for that. When I've traveled outside the state, I've talked about that as being something that is really, if not unique to Oregon, certainly a strength of Oregon's criminal justice and safety system is to have innovation. But when you're doing that, as you should, like a specialty court or an innovative program, you are requiring, as you should, altered behavior from what we've done before, because that's the whole point of innovation, is change your behavior. What Nancy funds by statutory and constitutional mandate is old behavior, is the way we've always done things. The defense is funded at a very, very low, efficient level with a standard from Strickland versus Washington that's basically, was the defense horrible? If it wasn't horrible, it passes muster, and that's okay. We want something different. We should be demanding something different. If you want
the attorney, the defense attorney, consistently there. If you look at all the best practices, you want them consistently there. You want them participating, changing their behavior, participating in the types of things like staffings of in a drug court. That's not contemplated in constitutional defense that way. And so it is very hard to fit that, to shoehorn that in. So now we're in this dilemma using our in Multnomah County, the START Court grant. Chair, you asked what's the difference, what's the effect of the cost shift? The effect in the START Court is the easiest way to fix that is to eliminate the defense function. And in those conversations, I mean, I'm looking at that, and if you're asking me from the perspective of should we get rid of START Court or should we have the defense function, START Court's great. It's doing some really wonderful things. I would rather, as a citizen of Oregon, see START Court continue than selfishly my system, within my office saying, does that fund a position that I can staff that with them? So in those discussions asked that way, I have to say, I'd rather see START Court continue. And if that's the only way it continues, that's the cost of it. But then it shifts it over to this other model, which is either expensive or ultimately gets you what you don't want, because Nancy could very legitimately say, I don't want to fund the way we've been funding with that one position. We'll just send people in on whoever it was before, like a PV, and they're randomly in there. That will have an erosion on the innovation and effectiveness of that court. Lastly, the thing I would say, unless you had any questions, is that I look at this, I mean, when you're doing innovation, you clearly should be paying for all the necessary functions so that you can control the factors of what you're going to get. You can dictate behavior by saying, hey, we're paying for that, right? When you're sustaining an ongoing system and you're sort of beyond experimental, like you are with a lot of these specialty courts, it really does come down to an equity issue, because then you're looking at, and I'll give you an example in a second, but if it's going to be paying for it ongoing, then you're going to say, well, if you're paying for this function, you should be paying the tab for all the components that you want there. In our JRI conversations in Multnomah County, because in that system, the district attorneys get, say, they think they get a full-time attorney and some support staff, but it's in the neighborhood of roughly, I think this last time it was about $250,000, $260,000. And the defense, because we were funding a coordinator, and I won't get into the weeds on that, was $60,000. And that was the look I got from Deborah Kafori, chair of the commission, when they're looking at me like, we're giving $250,000 to the prosecutorial function and $60,000 to the defense function. Now we can get into what that's actually paying for, but it doesn't meet that optics test. When people look at it, it looks like, well, what are we doing here? So there is an equity aspect for the ongoing, but the main message I want to leave you with is, when you're doing innovation, which is absolutely what you should be doing, this is the unique function that you perform within our public safety system, you need to pay for those components so that you can get what you want and you can change and require changes in the behavior of all participants.
Thank you. Any commissioner questions or comments?
Mr. Chair, with permission, I'd like to make a comment, and that is, until I decided to hang on my spikes last year, I was, for 12 years, the Director of Public Defender Services in Lane County, which is a smaller version of the operation that Lane described that he runs. And I'm here to tell you that what Nancy's office could pay my office to staff drug court, veterans court, mental health court, and juvenile drug court ended up in our office subsidizing those treatment courts, because at some point it's beyond how sharp is the pencil. At some point it's right and proper that the public defender's office participate in treatment courts. And I don't know anybody who runs the public defender's office in Oregon who would take a different approach to that question than we did. And so it's even worse than the panel has, my friends Nancy and Lane have spoken to. It ends up being subsidized by offices that are already running on a very tight shoestring. And so I fully endorse the comments my friends just made. Thank you, Mr. Chair.
Commissioner Blevett.
If I could just add as well, I agree with everything that was just said, and I agree with everything that the two of you said, and I'm going to say something that might not be popular, but I'm going to say it anyways. The reality is that the very first specialty court system I started in Lincoln County was before my time as district attorney. And because it had no funding for the district attorney's office, the then district attorney refused to even staff it. I understand her position. I disagreed with it. And I staffed it myself when I took office. But the reality is that we have 36 counties in Oregon. Close to half of them are, if it were allowed, they would be in bankruptcy. And the state legislature many years ago decided to walk away from district attorneys' offices. They only fund a portion of the salaries of the elected DA now. They used to basically fund a portion of all deputy district attorneys. They used to pay for our witness fees. They walked away from all that. And so I've been singing this cry song that nobody listens to in the legislature, and I'm not singing it anymore. But the reality is, if we truly want to fund all the key players in drug court, we got to fund the defense lawyer and we got to fund the prosecutor. Because when district attorneys make hard decisions about what cases they're going to prosecute and not prosecute, and when their budget's been cut to the point where all of their prosecutors are overworked, just like your folks are, they have to make hard choices. So if we're going to consider all that, and we should consider it, consider the whole system, because we got some counties that are running on a shoestring budget. Rant over.
Thank you.
Thank you.
Any other commissioner comments? Okay. Next we have from Marion County, I'm going to read the whole list and you can decide which order you want to go in. We have Danielle Farr, Dick Cohen, Mary James, David Leith, Lori Evans, and Dean Bagley, or Bagley.
Chairman Ball, members of the commission, I'm Mary James. I'm a circuit court judge in the 3rd Judicial District, which encompasses Marion County. I speak on behalf of the Marion County Mental Health Court. My views may or may not mirror those of the Judicial Department, but they are my own. First, I want to thank you for your past support. I also want to thank you for your commitment to treatment courts. The Marion County Mental Health Treatment Court combines evidence-based drug court practices with integrated human services to provide meaningful interventions and healthy, safe community living for our participants. The participant undergoes an intense evaluation and then a regimen of mental health treatment, behavioral therapy, case management, drug testing, and probation supervision while attending regularly scheduled status hearings before a judge. I've had the honor of serving in Marion County as a circuit court judge since 2003, and together with Commissioner Beglau and other public safety leaders in Marion County, I am a co-founder and now presiding judge of the Marion County Mental Health Court. Our court started in December of 2006. And it was born out of the usual frustration with observing people with mental illnesses come through our justice system, not understand why they were there or what the system was doing to them, and seeing them again and again, both in our jails, in our courts, and on our streets, untreated, and committing new crimes. And so, with the benefit of some National Judicial College training, with the benefit of observing the treatment courts in King County, which was one of the first treatment courts in the United States, we decided there had to be a better way. And we believe that the mental health treatment court is a better way to addressing the issues of people with mental illnesses who come into our justice system. For several years, we operated with no financial support other than the contributed time, the subsidies of the team members through the generous support of the Marion County Sheriff's Office, Parole and Probation Office, the District Attorney's Office, the Marion County Criminal Defense Consortium, and Marion County Mental Health judges who volunteered our time, and a trial court administrator who contributed staff time and staff support. What made our work heartbreaking was not having the means to allow uninsured defendants to participate. We had no means other than passing the hat to be able to pay for people to get their medications. We had no funds to provide housing assistance. We had no funds to ensure that people could get mental health assistance and behavioral therapies. The past couple of years have been far more gratifying. Our participants no longer had a financial bar to participating. They no longer had barriers to successful supports for sustaining recovery in our community. Being able to tell a participant that we can help with transitional housing to remove them from a toxic living environment meant the world. Having a coordinator go with a participant to pick up a medication. Having community-based, active, involved, and integrated therapy programs. Consistent UAs to provide participants with the knowledge that they were being held accountable for what was happening to them. And a probation officer who was trained to provide appropriate consequences and recommendations when there were slip-ups. We still have the results. I think you've probably heard this before from other persons who have spoken. The participant who just spoke mirrors my belief that compared to a traditional court, mental health treatment courts are such a different experience than a traditional court for everyone involved. In my view, it is better reinvestment in justice. Not only do we change lives of our participants, but we change the lives of their families, and we change the lives of the communities that we serve. We are a diversion court for the most part. In other words, instead of a conviction of a crime, our participants achieve diversion upon successful completion and dismissal of their criminal charges. We affirm individual effort versus what feels like condemnation when they are in a court and being sentenced. We require accountability in a way that recognizes what works with incentives, with consequences for choices, with frequent UAs. We affirm individual effort. We recognize small successes. Sometimes those successes are as much as the fact that the person came to court and didn't forget that they had court. We require frequent attendance, far more frequent than anyone on supervision, and we provide wraparound services. A personal interaction between the judge and the participant each week, 3 times a month. Personal interaction between the probation officer and the participant 3 times a month, and then it graduates to 2 times a month and then once a month until graduation. And integrated interaction with community service providers that allows the treatment team to be able to know what we're doing and whether it's working and whether we should look at another alternative. We provide increased services for people with co-occurring disorders because most of our participants have some form of addiction, whether it is self-medication or whether it's an actual addiction, either to drugs or alcohol or both, in addition to their mental health issues. And we have challenges, and so we're hoping that that this year you will see your way to continue to let us address those challenges. We still have some residual resistance by court administrators who cling to a more resource traditional view of courts as sentencing courts and not as treatment courts. Our coordinator is essential to us. She is a key resource to demonstrating the efficacy and the value of our court. And our treatment coordinator is also the treatment coordinator for our drug court. So she serves both, she wears many hats in taking care of our participants. And mental health court, as you know, has had and will have an additional hurdle in serving a significant number of participants who are either on Medicaid or Medicare or the Affordable Care Act, covered by the Affordable Care Act. Not all of our providers are able to bill Medicare or Medicaid, and mental health court takes on the financial burden to ensure adequate treatment for those people. Without sufficient funding, our program will not be able to fill in the gap to provide services that our participants need. Chair, you asked about cuts to various services and how they will affect our ability to help our participants. And one of the cuts that, in addition to the uncertainty caused both at the federal and state level in terms of funding for their treatment, is that the cuts affect our ability to comply with best practices for UAs that need to be frequent and consistent. Because those UAs cost money, and processing them, it costs money, and yet it's one of the most effective means to being able to hold people accountable for whether or not they're complying with the expectations to continue in their recovery and to be able to participate in the community and to get away from those barriers to stay successful. So I'll close by just thanking you. I invite any questions anyone has, and thank you for letting me be here.
Any questions? Sir?
Chair Ball and members of the commission. My name is David Leith. I'm a Marion County Circuit Judge as well, and I preside in the adult drug court. And we have together with me here members of our team. I love the way that Judge James presented her individual disclaimer. I want to adopt every word of how she said that. I am here in my individual capacity. I don't have any reason, though, to believe one way or the other, I suppose, whether the judicial department supports these positions. I don't have any reason to believe that they don't support what I'd be saying. I know that, or at least I believe that to some extent I'm here preaching to the choir, that you all already understand the value of specialty courts, drug courts initially, and the expanded specialty court model. So I won't belabor that too much. It was innovative at least once. The idea that rather than continuing to bang our heads against the old model, that we might try something different, a collaborative approach where the defense attorney and the prosecutor are part of a collaboration trying to work towards the shared goal of helping a sick person get better. And that's part of the reason to bring in the team and maybe do something a little bit different, let you see inside the team and hear from the perspectives of those collaborative team members. The model, of course, is built around some core principles, the combining treatment with random and frequent mandatory drug testing, incentives and sanctions, the participation of the court throughout the process, and the collaboration that goes into each stage of it, the staffing and the collaborative approach to determining responses to the different circumstances that arise. The model is proven. It was innovative once, and now it really is the established model for how to make people better. The most recent, I think it's, well, at least a recent National Drug Court Institute publication on best practices stated that drug courts have decidedly entered into a second generation of research on best practices. No longer preoccupied with the answered questions of whether they work, drug courts are now focusing their attention on characterizing the attributes of exemplary programs. Defining best practices is especially critical as drug courts go to scale and address the full scope of our nation's drug problem. These best practices are directly related to higher graduation rates, lower recidivism, and greater cost savings. And certainly the local peer-reviewed work on our drug courts have confirmed that locally we share similar statistical success with the national studies in terms of lowering recidivism and reducing costs. The success, of course, depends on adherence to best practices. If drug courts are not funded sufficiently, then we won't be able to operate according to best practices, and only by operating at best practices do we achieve the highly desirable societal and economic beneficial results. So rather than focusing on any further elaboration of the exactly what the judge's overview of the process looks like. I think I wanted to turn it over and let the team share their perspectives, and then I'm also looking forward to letting you hear from our one of our graduates of the program, Danielle Farr. So I think we were going to start with Ms. Evans from the District Attorney's Office.
Hi, my name is Lori Evans, and I work for Wald. I've been a deputy DA for 19 years, going on 20, and for all but 5 of those years, I've worked on drug cases, mostly drug trafficking organizations, so kind of the upper end of the drug problem that we have. And about a year and a couple months ago, we had a shift in the office, and I was appointed to be the representative from our office with the Marion County Drug Court team. And I had actually experienced drug court in my early years when I was down in Josephine County as a deputy DA down there. But coming into the team, it was a really fun process. In our job as a DA, we don't really get to see the successes. We continue to see the failures because they need help. And traditionally, I think when this program started, it's my understanding that the DA agreed to have a drug court as long as the DA's office could be the gatekeeper of who could enter into drug court. And so for many, many years, we had people that would qualify as an appropriate risk, but they were kind of the new users. They were not the people that had been in the system and weren't looking at prison or anything like that. When I took over, one of the directives I got was to take a look at some of these people that are the higher risk people, and because most of those people were on my caseload. And so I started with looking at people who were on probation violations, actually had a significant period of DOC time hanging over their head. We have, in the last year and 3 months, we have had 12 people come in to the drug court who were ready to go to DOC. In a traditional prosecutorial role, my recommendation to the court would have been DOC all day long. But we gave them a shot. And out of those 12, so far, only 3 people have not continued, one of which kind of came in a different kind of way. So let's just say 11. So out of those 11, we had a graduate today, and there have only been 2 people that have been kicked out. We have these people who are really doing a fantastic job. They've totally turned their lives around, and it's so much fun to watch. I have a guy that I've had on my caseload since about 2009. I somewhere along the line made it my mission to try and save his life. We would get the release agreements with his picture on it, and every time the picture was worse and worse, and he was more gaunt, and he was killing himself. And I was trying to be creative with him. We ended up hanging some DOC time over his head. He's been in the program now, I believe, right out a year. He's got a year clean. And he's very thankful for the ability to partake in this program. But it's very rewarding from a DA standpoint to be able to watch these individuals. That being said, we also have a fair number of 18, 19-year-olds who have been addicted to heroin for a good 5 or 6 years. And they come to court initially and they can't even keep their eyes open. They're on the nod, and we have managed to get a lot of those people initially housing. Sometimes it wasn't voluntary housing. And then we have got them obviously into treatment. They're getting jobs, getting their GEDs, and by the time they graduate, they're productive members of our community. And we've also began having an alumni group as well. So they have after graduation support as well. But anyway, from my perspective, drug courts are amazing, and it's very rewarding to be a part of the team.
Juan, Dick Cowan, defense attorney, Marion County, on the adult drug court. I know some of you. Rob and I had a little opportunity for me to visit his office when he was still there on his way out. It's a good time to go. Leave it like that. Sounds like a mystery. Mr. Beglaw, I welcomed to our team one day because he was being groomed by Mr. Penn, the DA, to take over. We were blessed in Marion County because we started out with the DA, as Mr. Bavette points out, personally as the representative. Dale Penn sat there forever until about the last 2 years as he was planning his next career progression. Then he started sending his right-hand man, who became the DA, Walt. And we had, that's just really beneficial. I won't bore you with how you run these things, but it's an awful lot easier to run it with the guy in front of you than it is the guy who's got to go talk to the immediate person, who's got to go talk to the supervisor person to figure out what the hell I told you at the start. It just really is simpler. I've been here since we founded ours. We've turned it all over in the last year finally. I'm the last remaining stander, if you will. And it still works exactly as it grew over that time because it became a completely collaborative process. When we talk about the efficacy of the program, the most beautiful things about that are having people like Danielle here to talk to you in a moment, and like the young man who spoke a little bit ago, and as Lori mentioned today, the graduates. There just isn't anything like it. It just happens to be, from my perspective, today's graduation was the greatest one we ever had. It was the first time we graduated a brother and a sister at the same time. They didn't come in at the same time. It just happened to work out that way. La Familia was there in grand presence. There wasn't a dry eye in the place when folks got done talking and sharing and talking about that familial reintegration that occurred from these folks. It's just simply beautiful. We did some other things in Marion County. When we talk about being innovative, even though stayed at a long time Oregon Drug Court, we've always been innovative and continue to be innovative. We added all kind of people to our team as we saw a need, and I preach this all the time. I sit on the OADCP Executive Committee as well as Jim Tierney mentioned. And I preach it to these folks constantly. Get what you need. Look around for what you need. When you talk about cost saving, how can you do it? We have a lot of free people there. I'm also one of Corzine's kids, and always have been for 16 years. Where, you know, what little pittance I get comes from there. And it is pittance if you count the hours, but you don't do that because this is one of those things you wind up loving or you're not there. You can't avoid it. We're blessed in Marion County until Judge Graves retired when Judge Leith came on. Graves retired 10/31 of 15. We'd only had one, which allowed you a continuity that was real valuable to what we did. So we reached out for everything in the community that we could snatch up that made sense. I remember maybe everybody doesn't remember this. Some of you people are young. We had the thing called the Great Society once upon a time when we tried real hard to do an awful lot of stuff. And then it got killed. But it didn't die. It went somewhere. And skipped the religious rite. It just went religious. It went to the churches. That's the one thing Little Bush was right about. The churches became terrific providers of communities, of services for folks. And we early on recognized that and brought first 2 from one church and then 2 from another church on our team. We have Oxford Housing has regional representatives. Our regional representative is on our team so that we have access to and can help people make the correction and the connection. He's not getting paid to be there. We have community members who are just simply community members. They had a particular background we wanted, we have them. He's on the team. Salem Housing Department, they run all the Section 8 stuff. Routine gig, get arrested for dope, Section 8, guess what? Tear up your certificate and you're booted. So we called them in, guy named Phil Dean, said, hey, why don't we work this out? What you don't want is you don't want people using dope, right? Right. You know they use dope a lot in these projects that you're working with. But here's what we can do if you don't kick our people out. We can provide you testing for these people. So you know these people are good. And, you know, that was a little forward thinking, and they bought in, and they're still in. Phil is now retired, and they have a new fella in his place. DHS has always been a player for us. Our coordinator was originally the DHS representative. That's Angela sitting back there. She served on our team as a DHS representative, and then went on in her DHS career, and that took her away from our team. And then later, when our long-term coordinator retired, guess what? We were able to hire her. She went through the process, did the interview thing, and won, and she's been outstanding. But DHS is still a presence on our team. Again, external monies. MCSO has always been there, the sheriff's office from the gate, the DA's office. I don't know whether Walter's office has a specific pot of money that says it's, you know, for that thing, but we've always had a dedicated person, and they've all been simply outstanding. In fact, I will confess, actually be happy to share, that this one I really like because we think alike, and that's a good thing. You know, I mean, she's got it. That collaboration just comes from being there, feeling it. We have a thing called Community Action Program in Marion County, which runs a lot of agencies' monies through it. One of their persons is on our team. It's just, you can do a lot of stuff if you think about it. And we've done a lot of stuff by thinking about it. We heard about a 501c3 idea once when we were at one of the national conferences. Some folks from Minnesota were talking about it. We got back, sat around, talked about it, looked at it, and figured it out. The judge at the time knew somebody who was in recovery who provided the legal services to us. You know, a lot of lawyers are dumb. They know the thing they know, and they don't know anything else. And don't ask them to do anything else. You'd be making a mistake. So we got a guy who knew how to do the other stuff, and we set up this 501c3. We also were smart, and we looped out the court. So we wouldn't be down here in your day today with you saying, well, why don't we get into your 501c3 and fund us? It isn't that big, but the first contribution we ever got came from Walter's office, forfeiture monies. And we built that bond and that trust such that at that time, he was able to hand me a check for, I was $45,000. And once he handed me that check was gone. But that's what collaboration will do for you. And we looped it so that the court couldn't do a thing. They weren't a member, a participant, and couldn't be. And we don't listen to them in terms of being directed or guided by them. We're there, we have a very direct purpose. We do the direct purpose. We certainly hear what they have to say. We're all aware of what we're trying to do. But it was done that way so that nobody could glom the dough. And we've had further contributions over time, and we've had other kinds of things that occur from the doing of that. But ultimately, nothing, and I'll just quit rattling. I can just do this stuff forever because there's nothing like it. Well, there really isn't. I happen to be in recovery for an awful long time. And it's the best thing in the gig, and the 12-step is given back. So it's always been a 12-step gig to me anyway. There isn't anything you spend money on that gives you more back in terms of, I think the young man laid it out very, very well when he talked about what you got's a productive member of society, not some deadhead, not somebody gobbling resources. He's not using resources at all. And if you got him back paying taxes and being productive, that's what you'll want. And then you get to the good human side. It just feels good. And we all should feel good for the doing of it. I didn't say hello to you all. Thank you. So I really appreciate the opportunity to be here. I hope that you have the opportunity when you reflect. It's a nasty job. You just feel free to do it because I'm not going to have any part of it. Somebody's got to make tough decisions, and you're called on. But you know what I like? I like what I got here. I got something that isn't one of those fakey shake deals. Now watch this thing. I got a chairman that runs the thing like it's supposed to be a thing. You got interested and intelligent interaction with the folks who are going to make the decision. That's real good. And you're listening to a bunch of other folks to get whatever guidance you can get from that. I will now hush down and hear from Dean, who's,
Thank you, Dick. I think
Best
you and I
deal
will
there
have to have a beer sometime.
well, I can't.
I don't know what time of the morning I'll get home, but.
I can't. We could, but I don't.
Okay. My name is Dean Bagley, and I'm a probation deputy for the Marion County Sheriff's Office, currently assigned as a PO to the Marion County Drug Court team. I've been a probation deputy for 19 years and have supervised various caseloads during my career, the most of which I was assigned to a general caseload supervising high and medium risk offenders with significant substance abuse issues. When I started supervising drug court caseload in August of last year, I quickly realized the significant impact drug court makes in the lives of drug-dependent and addicted people. I have observed the drug court participants generally have less police contacts in the community and commit fewer new crimes, and I find fewer violations when conducting home field contacts. Drug court participants often have full-time employment, allowing them to financially support themselves and meet their financial court fine payment obligations. Participants have a higher motivation level and engagement in treatment programming. Most importantly, I see participants making pro-social changes that allow them to become long-term productive members of society. I attribute these positive characteristics to the structure of the program and intensive team supervision approach, combining close supervision, intensive treatment, regular UAs, as well as clean and sober living. Additionally, I believe the participation of a circuit court judge as a member of the drug court team and regular court appearances reporting participant progress is crucial to gaining participant buy-in and motivation to address their addiction issues. I'm going to provide a few examples of who I have on our case and who's currently active on drug court right now. I'm going to use the name Gary. Gary's a former gang member of a motorcycle club with a total of 47 arrest cycles, including 24 jail sanctions and 8 parole violation warrants during his prior criminal career before joining drug court. Instead of going to prison for over 2 years for another drug conviction, he was given the opportunity to participate in our drug court program. He is now currently employed full-time and staying clean and sober. Since starting his program with drug court, he hasn't served a single jail sanction. Because he chose drug court, Gary's not currently incarcerated in prison. Instead, he plans to attend his daughter's graduation from college in Washington in a few months. My second story is about a man we'll call Robert. When Robert first started observing drug court sessions, he would regularly nod off during drug court hearings due to his regular heroin use. In fact, this participant was a motivating reason the Marion County invested in Narcan for emergency medical treatment in the drug courtroom. When he was first accepted in drug court, he was living alone in his apartment located in a high crime area where drugs were readily accessible to him. Robert began to work his recovery plan. He entered drug and alcohol treatment with Medicaid-assisted treatment. He was attending community support meetings 3 times a week and reporting daily to his PO. We first moved him to the Marion County Transitional Center as a voluntary boarder to remove him from the residential social triggers. Eventually, we helped him move out of the transitional center and into the Oxford House. He now has a full-time job. When he graduates from drug court, he will have a felony-free criminal record. His goal is to taper off Suboxone and become a supervisor with his new employer. He is now assisting other participants, helping with rides and transporting newcomers to support members and helping fit in with other members of recovery community. And I got an email from his mother in December, and I'm just going to have a quote of what she said. "I'm beyond grateful for the changes I am seeing and how he is growing mentally and spiritually. I hope you are seeing positive changes too. I want to thank the Oregon Drug Court Program, the judge, etc. for all that you do for Robert. Right before Christmas, the best gift I ever gotten is him being in recovery and staying clean. I know it will be a rough road ahead at times. Life is like that. But it's wonderful to see him on the path he's on right now." I have several more stories like this I could tell you. I share these experiences with you because I've seen firsthand how drug court changes people's lives. In my 19 years of experience as a probation officer, it is personally motivating and encouraging to be part of it. And I thank you for your time.
And we'll conclude with Danielle.
Yes. These things always make me nervous. I want to thank you for allowing me to be here. I'll give you a little bit of history of who I used to be, because it's really not the person who's before you today. The person I used to be was one of high-risk offenders. I presented to the Marion County courts with a series of charges. I had the accidental brilliance to keep getting additional charges before I was fully sentenced on my previous charge, so they just kept piling up, and I was released on my own recognizance because, for whatever reason, I kept showing up to court. Because of this, I ended up with a DCS2, several PCSs, because I had no way to arrest my addiction, only to continue to get arrested. I was facing 3 years, no AIP, no good time. I remember the face of the DA who was prosecuting that day, and Judge Graves at the time, kind of off the cuff, said, you know, it's a shame we don't have any more funding, because you might be a really good one to have in my drug court program. And I said, wait, call my mom. And he did. He went into chambers. This DA assumed they had it in the bag. You know, this was going to be an easy 3-year sentence because I had no reason to be demonstrated as a hopeful candidate. I've been through treatment as an adolescent and as an adult and never done anything even remotely successful. I was a young mother. My family had the good sense to remove that child. I was never a part of DHS, but again, there were no redeeming qualities in my life. But in that moment, the judge sought, and I don't know whether it was to disprove me and show me one more consequence of my actions, but my mom said that she would pay for treatment. There were no funds. She paid for the straight facts treatment in order to allow me to give me the rope to hang myself in drug court. I did my absolute darndest from day one. And I think this really speaks to the necessity of drug courts. Once accepted, I gave it my best, and unfortunately, it wasn't much. My ability to make rational decisions was laughable. My best effort was continue to use alcohol because I wasn't using meth anymore. So just using alcohol was somehow in my mind legal, though I was on supervision. I thought that was a decent choice. I thought of myself as successful at that time. I did have a relapse on methamphetamine a week into my drug court program. I used that relapse to complete all of my treatment program homework for that week because I thought in my mind that was a good use of my mistake. That was the best I could do. I was, of course, sanctioned, and I went into custody. Because I did not have insurance and there was no funding, there was no option for residential treatment. So I did residential in Marion County Corrections, 23-hour lockdown at a time, and showing up to court in shackles every Friday. This was humbling and probably exactly what I need. Every week I would craft a very lengthy letter on whatever piece of paper I could find with a teeny tiny pencil, and tell the judge why I had it all figured out and why I needed to be released. Again, my best thinking scribbled in horrible penmanship, which is still not improved, my desperate plea to be able to go back and make my own choices again. The judge was a wise man and remanded me to custody again at the end of every week. And this went on for, I believe, a month in general pop, and then I got transferred to the work center. Once in the work center, I had a few more freedoms, and I continued to make my best choices. I passed notes with male peers. I had contraband almost constantly. I deviated from my passes because I wanted to do those things real quickly so I didn't have to worry about them later. Again, my best choices. I stole a pair of work center pants and hid them in a bus locker. This seemed like a good idea at the time because I didn't have regular access to pants. Just so you know, it was over 7 years ago. In my early stages of recovery, I considered prostitution as a viable means for earning income because I had no real job skills. I considered selling my clean pee as as a way to earn income because I had no work skills. This was my best thinking. And I say this not to shock or even as a form of self-deprecation, but in early drug court, that was the best I could do. And some of that was even 2 months in, 3 months in. My rational thinking was so far removed from pro-social thinking. My best efforts, and they were sincere, were not sufficient for me to be able to do this in a simple outpatient program. I had tried outpatient. I had wanted recovery. I wanted so desperately to stop hurting my family and my children. I didn't think I could, and I know that without drug court, I would not have been capable. My best efforts landed me in that courtroom, desperate, dying, and worthless in my own defense. I needed that team to be able to support me. I wasn't well, and my best efforts couldn't have gotten me there. Excuse me. Despite myself, the team held on to me until I could take care of myself. They required that I go to sober housing. They required that I get employment. In fact, one of my first jobs was across the street at McDonald's. I had a great time working there. In fact, I was passed up for promotion several times for not taking it seriously. I think even then I knew that it's not where I was headed, but just where I was. Drug court maintained rigorous expectations. So although I was not all that great at much, they held me accountable for everything that I missed and showed me how I was certain to be able to make sure I got there every step of the road. They required mental health because certainly I was a mess. They provided me encouragement towards volunteering and community involvement. This seems like a small piece, but really this was the keystone that helped me to go everywhere. This put me in front of police officers and the movers and shakers of this county so that I could be seen as a human rather than a wreck. I began to be able to see myself through their eyes, not as some sort of mascot or token person in recovery or, hey, at least you weren't doing what you were then. But I was a human again. And that opened doors for me. That allowed me to be able to go into college and work along other students and not see myself as a felon first, but as a woman and as a mother first. For those of you who have taken sociology, is one of those earth-shattering moments for me was when we discussed master status. And most people have master status identified as male, woman, mother, father. My master status walking into a room was felon. And I felt that that's something that was important to my identity. And although it still has a lot of factors in how I move in my world today, it is certainly not how people know me. And in fact, most people that know me today don't know that about me. Things that I think are important to know when considering funding. Had I not gone through, or if I had not come from a middle-class family that had the ability to pay for my treatment, I wouldn't be here today. I would have done the 3 years, no AIP, no good time. I would have been another woman filling those beds in Coffee Creek and making us consider the budgetary impetus of opening a whole new facility. I would have been taking up one of those beds. Instead, I'm here. Anecdotally, I see many folks in treatment today as a professional with a lot of really great intentions, but they can't put those pieces together on their own, and treatment alone is insufficient for so many people without the full holistic modality of drug court. The community impact. Of course, there's the I don't commit crimes anymore piece, but realistically, I don't think this is the most impactful part to the community. I wasn't very good at committing crimes. I got caught most of the time. I was awful at being a criminal. I think the part that does make a huge difference is I live in a community. I'm an active member of that community. I pay my taxes, I think upwards of $40,000 this year between me and my husband. I'm willing to release those records if it becomes imperative. I volunteer. You know, I'm the first one people call if they need somebody at the church or in an organization. I think it's fun. I get to meet new people. It's been a pattern that's been habituated in my life. I play with my kids. I play with them every day. I play with my neighbors' kids, and they let me. I go to my parent-teacher conferences for my kids, which means that's a little bit less effort that those teachers have to put into raising and teaching my children and trying to adjust their behaviors, because actually I'm there. I work to support my family. I am a daughter and a mother, and that adds to the life of my loved ones rather than takes away. Personally, my father was in a motorcycle accident recently, got bumped in the head. He's a high-ranking executive, and he's not good at not knowing what's going on around him. He has been staying with me because he trusts me. I'm responsible. I'm dependable. That would not have been the case 12 years ago. I did pay all my fees and fines, which had been pretty substantial by the time I'd racked them all up. I seek medical care currently at a reasonable and responsible rate. I'm not in the emergency room looking for pills. I see preventative care, and that has an impact on our healthcare system in a positive way. I'm not on any assistance of any kind, and this did take me a while. I was on assistance for food stamps and medical for a time after drug court, but was always on an upward trajectory, and that takes and alleviates the burden of our other systems. And I know you asked the question of, you know, the $9 per day. I was in drug court for roughly 570 days. And at $9 per day, this cost $5,130. If we revisit what was purchased, that $5,130 bought parents for my children. It bought not having to pay for a 3-year prison sentence. It bought $45,000 in taxes this year. I'm not resentful. It bought everything on that list. So when we're talking about reinvestment in the community and can we afford drug court, we can't not afford drug court. This is not a question. We can't afford not to do this. This is cheap in comparison. And in addition, when we're looking at the services that drug court provides, we talked about, well, you know, some of these don't get up to beyond a shadow of a doubt because of fidelity of the model. There was nothing a part of this drug court process for me that was built to be a luxury. And my survival depended at that time being able to pick out what those luxuries and freebies might be. There was nothing in this that was unnecessary. And if we start to limit the contact or the frequency or the quality of care that we're providing for these folks, we really start eliminating that fidelity of that model that is effective. My biggest fear would be to limit the fidelity of the model and sort of cheapen that brand, and suddenly we don't get to attract the high caliber professionals that want to work for this field and the community partners that are excited at the opportunity to join these panels for free. We, in reputation, get to have a lot of participation and standing in this community, and if we cheapen that at any level, we lose a lot of what makes us effective. And I think that's all I have to say about that.
Thank you, Danielle.
Oh, you may. Thank you.
So in closing for the team, I'd just like to invite you all anytime you want to come and visit our Marion County Adult Drug Court Friday mornings at 10 o'clock. We staff at 8 o'clock, and we're in court at 10. Thank you. And if there's any questions, we're here.
Thank you very much to all of you. Any questions from the commission?
No, just thank you very much, and thank you for your story. Obviously, I've heard similar stories staffing a drug court, but you are very talented at expressing the core of it. I wish I could have 90 legislators listen to you say what you just said. And yeah, and most of them get it. They do. I mean, we had a couple of great presenters at a recent Justice Reinvestment Initiative that gave similar stories to you in the presence of probably half dozen legislators, and they were all nodding their heads. But sometimes we talk about numbers and federal budgets and all this other stuff, and sometimes we forget what it really means. And you just outlined all of it. It's right there. Thank you.
Thank you.
Mr. Chair. Thank you all. One quick, Mr. Chair.
Commissioners, sorry.
And as they're clearing out, I just want to say one of the threads that's even before our public portion of this testimony, one of the threads that this meeting has, I think, brought to the fore is the notion of best practices being really requisite for drug court. And so, as we talk about funding issues, even in further meetings, I mean, they all seem to be pretty consistently saying that best practices are critical for drug court. You can't diminish the brand, is basically what they're saying. Right. So that's just something I wanted to point out before we bring the next people up.
So, commissioners, we have technically 18 minutes left. We have a group that came a long way from Josephine County. We have 2 other individuals, so I would propose that we bring up the 2 individuals first and give them each 3 minutes, which is not a long time, but then bring up the group so we can hear from them, and if we're over just a little, or does that work for?
I'm willing to stay to hear all of them.
Okay.
Yeah, I've got till 4:50 on my meter.
Okay, great.
I've done these meetings before.
Let's bring up the 2 individuals first, Anne Marie Simmons and David Reese.
We're separate, but go ahead.
Yeah, that's fine. Yeah, you can. Why don't we go with Anne Marie first? She's first on the sign-up list, and then we'll go with David. Then after that, we'll bring up the group from Josephine County.
Good afternoon. I'm Judge Anne Marie Simmons. I'm from Douglas County. Blue light on. Got it. Okay. I wanted to thank all of you for allowing this time to have stakeholders in treatment courts come in and present comments to you. I would, I guess, reiterate that the views that I'm expressing are my own as an elected official from Douglas County. I am here, however, at the direction of the presiding judge of Douglas County, and all of the judges in Douglas County are supportive of treatment courts. I'm here with Mr. Wilson, Robert Wilson, who is our treatment court coordinator. We in Douglas County have 3 treatment courts. Hope Drug Court is one of the oldest drug courts in the state of Oregon. It's celebrated its 20th anniversary in December of 2016. It has 493 graduates, and I think that they're currently serving over 60 persons in that drug court currently. And of course, that's a rolling enrollment, just like all treatment courts. We also have a domestic violence court that is not grant funded, and that provides treatment to domestically violent offenders, and that has been in existence for approximately 17 years. My court, mental health court, was established in August of 2014. We have a serious need for mental health services in Douglas County. We currently have, as most of you are probably aware, a VA facility. And while that provides some services to their clients, we also seem to attract a certain number of individuals because of the VA services who have contemporaneous mental health needs that are not getting served. Our mental health court has currently got approximately 36 members, somewhere between 36 and 40. We have admitted 59 individuals since the court started. We have graduated 7 of those individuals, 3 since the beginning of this year. We're, I think, anticipating graduating 2 more probably within the next 2 or 3 months. And we have had 26 referrals for mental health court. One of the things that our county is doing right now and stressing is the importance of identifying which characteristic an individual falls under. Obviously, you all are familiar with the treatment court program models, but many of our clients in mental health court and in drug court actually have crossover. Sometimes we're treating someone in drug court. It's not working very well because what they really have are largely untreated mental health issues. We have individuals who are in both courts. We have had a number of veterans in mental health court and will continue to do so. Some of their treatment is received by the VA and some of it is not. We have established teams for both, well, for all three courts, but particularly for drug court and mental health court that include a wide variety of community members, including NAMI for the mental health court, DHS, law enforcement, the parole and probation department, who has graciously, although they are not funded to supervise misdemeanors or supervising misdemeanors in our mental health court. I can't emphasize to you the importance to which I place treatment in the community for individuals in drug court and mental health court. There are so many services that go into that treatment, and you've heard from a lot of different perspectives. But the number of services, frankly, is often overwhelming for the individuals who need to be receiving them. And without treatment courts to help sort of supervise and marshal those services, it would be nearly impossible to get the persons who need the treatment all of the different types of treatment that they need. Just in sort of abbreviating some of the comments that I wanted to be sure and express to you here today. Nearly all of the individuals that we're dealing with in either court, regardless of the level of their crime, would be considered high to medium high risk on almost any standard. None of these people are coming to drug court or mental health court with this being usually their first entry into the criminal justice system or even low-level felonies or misdemeanors. We have a number of individuals in both courts who are on downward departures. Drug court is currently serving as our aftercare program for our residential substance abuse treatment program. So once those individuals are released, they're being supervised by drug court as their aftercare program. These services are critical. Our community lacks a number of services. We are marshaling all of those services together rather than trying to send individuals out to sort of work the maze of, do they have insurance? What is their insurance going to cover? Can they get their medication here? Can they get their medication there? We have case managers who are working with these individuals to make sure they have housing. Housing is a critical component to these treatment courts. We have, I think, no available housing right now in Douglas County, and we currently have most of our mental health court members who need housing on some kind of waiting list at a number of different facilities. It's not there. So we have a number of issues that we are trying to reach in terms of funding, and any funding is funding that we need. But I talked to Joe Garcia, who's head of our parole and probation department yesterday. We laughed because I said, can you get a UA, a confirmed UA with a lab result for $9? And he said no. And I said, well, neither can mental health court. We just can't do it. So it is critical, I think, to the health of our community to be treating these individuals if we can in our community. I certainly think that the costs are lower. I think it's important to our community to be responsive on a community level to individuals who need these services. And we are certainly grateful for funding that you can send us. Douglas County is not a wealthy county, and we are very, very grateful for what you've done before and hope that you're able to continue funding us. Thank you.
Thank you. Thank you very much. Questions or comments? Mr. Reese?
Thank you, Chair Ball, and members of the commission. I'm David Reese. I'm a circuit court judge in the 4th Judicial District, which is Multnomah County, and I have the privilege of being one of the judges that presides over our DUII intensive supervision program. And I want to thank you for the opportunity to be here today. Although this is a difficult budget environment, it is, the bigger picture is that it's an exciting time in the criminal justice system from the 10,000-foot level in terms of innovation and changes. And with this commission's leadership, Oregon is leading the way, I think, in coming to smarter, more cost-effective approaches to criminal justice that most importantly reduce the risk of future victimization of members of our community. So I want to thank you for this opportunity. Although we are in a time of innovation, I'm here today and to talk about a program that's been around for a while. There is a tendency, I think, in the work that you're all doing to focus on new shiny things. And I'm going to talk about a program that actually has a history of, that goes back decades. The DUII Intensive Supervision Program has been around for a while. And I think it's important for, I want to, well, you know what, I forgot my usual, you've already heard everybody with the usual disclaimer. I'm not speaking today on behalf of the Oregon Judicial Department. That said, that doesn't reduce my passion for what I'm here to talk about today, which is the DUII Intensive Supervision Program. We often refer to it as DISP. So I'm here to advocate for maintenance of this program that has, that right now is the largest DUII court in the state of Oregon. In fact, it's one of the largest in the country. We currently serve and consistently serve 175 to 200 active probationers. We take hard cases. We target high-risk offenders. The average participant in our program has more than 3 DUI convictions. We have, in our history, departed hundreds of folks from presumptive prison sentences. In fact, I did just yesterday. We take hard cases, we target high-risk offenders, and I think, importantly, we have a track record of success. We have been keeping statistics since 1998. I'm accompanied today by our treatment court director, John Dieter, who was instrumental in starting that process way ahead of the curve in terms of maintaining comprehensive statistics on our program participants. And I can tell you that 75, and again, starting with the premise that we take hard cases, 75% of our participants graduate. And of the folks that graduate, 88% do not reoffend. And that recidivism rate is measured at 5 years. So we keep careful statistics. I would dare say, going back to the presentation on burdens of proof, I think we meet the beyond a reasonable doubt standard. So I'm here to advocate for the program because we do high impact work. I don't think I probably need to explain to this group that driving under the influence of intoxicants, I think, causes more damage in our community than any other crime in terms of, you can measure it in dollars and lost lives and damaged lives. This is high impact work. The other thing I want to point out is I think as we go forward, I think we can fulfill a role as a tremendous resource for the state. We have a long history of an innovative approach, and we've certainly evolved over time in terms of our practices and aligned our practices with best practices. With this commission's assistance, last year we just implemented a new risk assessment program. Every participant in our program goes through a risk assessment. It's called the IDA or IDA risk assessment. That was in part because of help from this commission. This commission helped us train our whole team. And I should mention this is a team approach. There are judges involved in this. There are 2 judges involved in this program, myself and Judy Matarazzo. We also meet on a regular basis with treatment, with defense lawyers, with DAs, with probation officers, and I think probably the real backbone of our program are case managers. The whole team, because of help from this commission, was able to participate in training. I think that's especially important for our court, the largest DUI court in the state, which can be a resource for other DUI courts as they pop up, that we be particularly versed in best practices and certainly moving our program to the absolute to our best possible way in terms of what funding allows to implement all those best practices. And I think we've certainly measure up in that respect. In fact, one of our proposals for grant funding is to have our program studied by NPC to make sure that we are aligned as closely as possible with best practices. I think that is important with our leadership role and the resource we can be for other DUI courts. But the other thing I wanted to mention is with our grant proposal is that I'm concerned about maintenance of our program, because we've been around for a while, and we're not the shiny new program. I'm concerned that we maintain our status as an effective leadership court in this state. We have primarily been funded by our own judicial district. There has not been a lot of outside funding for our court. Again, our history goes back into the late 80s and early 90s. This is a difficult budget environment, as you know, and I'm concerned that if we lose positions, and to answer Chair Ball's question at the beginning, if we lose funding, and one of our proposals is for funding to make sure that we maintain our case manager. Right now, our case management level is approximately 50 probationers or 50 participants per case manager. If we have to cut back and go to thin the soup, so to speak, we just won't be as effective. We won't be able to maintain the best practices. We won't be able to do this really important work at the high level that we're doing it. So I'm here today to advocate for maintenance of our program, because I think we are such an important leader in this area of high impact work. And with that, I'm happy to address any questions that any of you might have.
Questions, comment? No. Thank you, sir.
Thank you.
Appreciate it. I have Joshua Sharp, Sean Beeman, Amy Wells, and Carol Stevens. Thank you very much for waiting till the very end. It's a long wait after a long journey, so thank you.
Good afternoon. I'm Amy Wells. I'm the coordinator of the Josephine County Adult Drug Court. Thank you for the opportunity to allow us to give testimony about our program and the critical importance of funding. And I'll try to be respectful of time. I know that the Josephine County Adult Drug Court began in 1996, 21 years ago. Since that time, we have and we are a small rural county. We've graduated 363 participants, and we've had 32 drug-free babies born in our program. Our team includes Presiding Circuit Court Judge Lindy Baker, the District Attorney's Office, Community Corrections, the Southern Oregon Public Defender's Office, the Grants Pass Department of Public Safety, our case manager, counselors from our treatment agency, Choices Counseling Center, and myself as the coordinator. We also include the Department of Human Services and the Veterans Administration on cases that we have in common. The entire team is at the staffing every week, and the entire team is in court every week. Josephine County, We certainly have funding issues, but the commitment to this program from all of our community partners and agencies is absolute. We had a graduation last month. Our sheriff was there, the chief of police, the head of every agency in the community was there. And Mr. Stark, who has left, he actually spoke at our graduation last September. So the buy-in from our community is enormous. And we run a great program. Right now, our recidivism rate for graduates is at 2.6%. And we don't take easy cases. All of our people that come into the program are high to medium high risk offenders. Lately, we've been allowing a great deal of downward dispositional cases to come in that would otherwise go directly to DOC. I would say about 60% of the people that have been coming into the program over the last year would fit in that category. Our community, we are constantly evolving as a program to envelop all of the current best practices at both the state and federal level. We avail ourselves of training, webinars, anything. Our team is committed to doing best practices and the best program that we can possibly do. After years of running at about 30 to 35 participants in our program, currently we're at 60, and the need is growing. It doesn't look like it's going to go away. The rise of heroin in our community has taken its toll. Right now, between 85 to 90% of our participants report heroin as their primary drug of choice. The dynamics of opiate addiction have required some adaptations to our program. To address early engagement and retention issues, the intake orientation process, we have streamlined it. We do a lot of those cooperatively when people are in custody. We're meeting people wherever they are, getting them wrapped up in services. And we have a very active peer mentor program, and my other team members will talk about that. Our community recently opened a clinic to offer medication-assisted treatment. Our treatment providers established a relationship with them in order to shorten the wait time for medication and monitor compliance with the protocol. Housing is, again, our biggest challenge. There just isn't available housing. And again, I think that kind of goes for a lot of the state. Continued CJC funding is critical to the basic function of our program. This year we've requested funds from the CJC for personnel only. We're asking to pay for half of a deputy district attorney, half of a probation parole officer, and my position. Without funding, it could be very difficult. And if you are familiar at all with Josephine County, our public safety funding is kind of at a critical stage. And I'd just like to end my part really quickly with everybody here is passionate about drug courts and treatment courts, and we get to bear witness to a great deal of tragedy and trauma, but we also get to see people transform and change for the better. And it's amazing. It's an honor to be able to do that. I'll just leave you with a quote. I did an exit interview on an older man last summer who graduated our program. And he's from the Cave Junction area, and definitely he had 40 years of methamphetamine addiction. And it had taken its toll. But the quote that's really stuck with me is that I asked him what drug court had given to him. And he's told me that, drug court gave me my good back. I feel like a good person again. And I wasn't a good person for a really, really long time. And I think that those are things that you can't assign a number to or dollars to, but that's the core of what we're doing. We want to give people their good back. We want them to be productive members of our community. For people who don't understand that part, it's also cheaper. It's significantly cheaper than sending people to prison. So that would be, and I will turn that over to Sean Bayman, one of our treatment counselors.
Hello, my name is Sean Bayman. I'm a certified alcohol and drug counselor, level 2. Thank you for the opportunity to speak, and thanks for acknowledging our drive. The truth is, I would drive twice as far on the opportunity to advocate for drug court, and I think they would agree with me. Since October of 2014, I've had the privilege to be a member of the Josephine County Drug Court team as a representative of the program's sole treatment provider. It's been an honor to be part of a program that gives drug addicts who commit crimes the opportunity and a chance at recovery, as opposed to punishment and the traditional involvement in the criminal justice system. I've witnessed several drug court participants radically change their lives for the better through their involvement with our drug court. This includes one opiate-addicted addict, while enrolled in drug court, who overdosed on heroin in a grocery store parking lot and whose life was only saved by the administration of naloxone by a first responder. With the help of our program, this individual has now been clean and sober for 18 months. He is employed. He's an active member of our alumni program and is also an active member of our newly established mentor program. As a treatment provider, every day is spent on the front lines battling the disease of addiction and its devastating effects on our community. In a drug court program, it is the treatment provider who gets the most regular contact with our participants. In our role as a treatment provider, we have taken significant efforts to adhere to both national and Oregon adult drug court standards. There is also an effort to maintain fidelity by providing evidence-based practices, manualized treatment curriculum, and an effort to provide groups that take into account gender-specific needs while balancing criminogenic risk. One of the things I'm most proud about our program is the actual drug court team. During our staff meetings that are held prior to our weekly court sessions, each member of the team is granted equal voice in discussion, and treatment concerns are addressed with the same seriousness and consideration as legal concerns. Our team is successful due to following best practices and having regular communication that occurs on an almost daily basis. Our team simply listens to the concerns of the treatment provider. Areas which we have been able to improve as a treatment provider over the last 2 years have been the addition of 2 case managers, expanding drug testing capabilities, and the implementation of our mentor program. Case management has been proven vital to our program as it allows for the variety of treatment services to be delivered to our participants in a more timely fashion, as well as the ability to provide outreach services to meet our clients where they're at. Case management also significantly enhances the team's communication. We have recently obtained funding for expanded urine screen panels and different means of drug testing, including oral fluid swabs. As designer drugs invade our communities, we need to be able to test for these new substances due to a history of our participants using substances that they know they will not normally be tested for. It is also imperative to be able to offer alternative means of drug screening, such as the oral fluid swabs. Over the last 2 years, with the help of one of our case managers who's here today, we have been able to develop a drug court mentor program. Typical activities of a drug court mentor include picking up individuals upon release from the jail and transporting them to the intake and orientation process at our treatment center. This also includes transporting individuals to and from residential treatment centers and regular mentor-mentee groups. The main difficulties that we face as a treatment provider working within the context of a drug court is the lack of housing, lack of access to residential treatment beds, and lack of access to medication-assisted treatment, such as methadone, Suboxone, and long-acting naltrexone, which is marketed under the name of Vivitrol. The lack of housing resources affect all in our county, and it's not limited solely to drug court participants. Availability for housing currently sits at less than 5%. Access to residential treatment for our participants is limited by a lack of local residential treatment centers, as well as which treatment providers throughout the state will accept payment through the Oregon Health Plan, of which the majority of our participants are enrolled in. Finally, despite the fact that the Grants Pass Treatment Center, a medication-assisted treatment facility, recently opened its doors due to the huge opiate problem that I'm sure you've heard a lot about, they are currently at capacity for accepting new clients, and at this point have a waiting time of approximately 2 weeks. There is also a lack of physicians in our area that are licensed or even willing to administer medications such as Suboxone and Vivitrol. Even with all these difficulties that we face through our drug court, we simply have the ability to change lives in our communities for the better. Thank you.
Thank you.
Hi, my name's Carol Stevens. I've been given the privilege to work on the drug court team in Josephine County since August of 2015. My role on the drug court team is a case manager. I do various jobs. I get the opportunity to meet our population where they are at. These jobs include finding housing, finding transportation, removing financial barriers, assigning mentors, going to the jail, planning activities, approving activities, preparing individuals for schooling, and the list could go on and on. I am also a counselor to some of the individuals. Josephine County's drug court is special in my eyes because we have embraced resources that have helped us flourish. Our mentor program is flourishing. About 60% of each group that graduates participates in this program. Our mentors are sent to training and given specific skills to help our new drug court individuals. We just had our first group of mentees become mentors. We also have a huge alumni. We have alumni meetings, and we have an alumni chair, vice chair, and secretary. These individuals are special to me because I am also an alumni. I graduated in April of 2004. I am the first alumni to come full circle around and now become part of a team. Josephine County embraces recovery. Our recovery fair that we have in September has a motto, "Recovery lives here." It's very apparent that our community cares about recovery, and because of this, we have learned to branch out our drug court all over the community. We raise money in the summer doing car washes. We sell hot dogs and drinks at Boatneck, the biggest event in Josephine County. Last Memorial Weekend, during Boatneck, a usually difficult weekend for most, we did not have a single relapse due to the booth and support of our alumni group. We also have a successful softball and basketball team that plays in our city league. In the fall, we have a huge chili cook-off, and at Christmas, we take all the money that we've earned and pour it into presents for the drug court children. I believe that Josephine County has taken drug court to a new level. We will be inviting all drug court alumni in Oregon to a mentor training in November to try to share our newfound strengths in hopes that we can help all drug courts in Oregon flourish. And that's my speech. But my heart is with our mentor program because I understand what it's like to be a participant. And so that gives me the upper hand to kind of meet individuals where they're at. And if it wasn't for drug court in 2002, where I spent 17 months in, I don't know that I would be standing here today or sitting here speaking to you today. And it means a lot to me. Without drug court, we're not saving lives. I mean, we save money, but we're not saving lives. I had a mentor that a year ago, she had relapsed on the day of graduation, and we ended up sending her to jail and then to residential treatment that day. And she came into our courtroom because she just graduated and was going to take another person to an appointment that they needed to go to from court. And she came over to our box and looked at us because somebody was up there trying to tell Judge Baker some kind of lie or do some kind of triangulation. And she just shook her head and she goes, "I'm glad I'm doing what I'm doing." And she's thankful today. And that's why I do my job, because I am super duper thankful for drug court because it saved my life. And now I get to give back. And I think the biggest thing about not going back to jail and all of those kind of things is that people get to give back. And we've embraced that. Our community has embraced that. And we get the opportunity to just get people out into the community. I'm also in leadership for Celebrate Recovery. So that's my outside support. And so getting all the resources that we have in our community and getting people to help us in any way, shape, or form that we can helps flourish our drug court. And so without drug court in our community and the funding, I just think that we'd be in big trouble. So thank you for the opportunity for listening to us. And just thank you.
Thank you.
Good afternoon, everyone. My name is Joshua Sharp. I was here to speak about our alumni, but Carol kind of stole my thunder. I think a little bit about myself. I used methamphetamines for 22 years. I have 56 misdemeanors, 21 felonies. I'm an A1 on the grid, so the last time I was going to get arrested, I saved you all like, I don't know, $600,000 or something by not going to prison. I think for me, drug court was huge because court was just court. A couple of months in jail is a couple of months in jail. 8 months in jail, not a big deal. But when I started going to drug court, it was like somebody actually cared. Somebody didn't want to put me in jail. Somebody wanted to address the problem. I had no idea that there was such thing as recovery at all. I committed crimes. I did drugs. I went to jail. I got out. I committed crimes. I did drugs. I went to jail. And it was just this endless cycle. I didn't even know what NA was. And then luckily, some public defender, his name is Peter Smith, most generic name ever, but he's a wonderful man. He said, man, maybe we can get you into drug court instead of sending you to prison. Yeah. Right? Pete Smith. Love him. I didn't care. I would have signed anything at that point. You know, you want to put me in prison for 20 years or do this drug court thing, I'll do it. Whatever gets me out of jail this time. And honestly, I had no intention of not doing drugs. My intention was to get out of jail. But I started going, and I met a probation officer, Tom Van Arsdalen, and I mentioned him because he was a key factor. He carried a badge and a gun, and he wasn't mean to me. He didn't treat me like a piece of crap. He didn't treat me like a drug addict. He treated me like a man. I mean, I was 35 years old, and he just treated me like a man. I mean, he spoke to me man to man. It wasn't like this guy behind a badge and a gun. It was going to push my face in the dirt and, you know, read me my rights. It was a fundamental change for me. It opened my eyes. I woke up. It was like there's like this whole other thing. So today, I'm an active member of our alumni. I've been the chairman of our alumni. I've been the vice chairman of our alumni. I've been the treasurer of our alumni. We play softball, we play basketball, we do tons of pro-social things. And I can sit here and I can tell you that a third of our 12-step community leaders in Josephine County are alumni from drug court. They're the secretaries of those meetings. They're the chairman of those meetings. They're the treasurers of those meetings. We don't breed, drug court in Josephine County doesn't breed recovering addicts. We breed leaders in recovery. I mean, I can't tell you, I don't know if I'd have been in any other county, I would have been successful. I can tell you another thing. I test for my KDAC, my Certified Drug and Alcohol Counselor test, this July, and I work for a different treatment facility. And we refer to it like herding cats because I'm on my own. I don't have what these guys have to try to help these people. And I wish every day I did. You know, I wish every day I could provide the services that drug court provides, the thing that you guys help fund, but we just can't. So with that, I'm a single dad, and I promised my kid I would take him to IHOP. And he's outside. So thank you all for listening. You know, you really are saving lives, and if you're not saving them, you're changing them. You're changing them for the better. So thank you.
Thank you very much. I think that concludes our public testimony.
Just really quickly, I have a letter.
I'm sorry.
I'm sorry. I have a letter from Judge Baker. There's copies for everyone. She couldn't be here because she was presiding over drug court today. So.
Great. We'll make sure that everyone gets those.
Robert Wilson from Douglas County. I don't want to take up too much more of your time, but there's something that I feel is important to kind of point out in regards to mental health courts specifically, in that there's a difficulty in getting accurate research for mental health courts that is not present for drug courts. And I felt it was important to point that out. Drug courts is very easy to look at and get a kind of control look. One county has drug court, one county doesn't. It's a drug charge. It could be drug court. You know how it would have panned out with or without drug court. Mental health court, very different can of worms, as it were. There is no mentally ill in public. That's not a charge. So someone could have mental illness, which could be contributing to the substance abuse, the theft, the menacing, the assault, and it's hard to have a control. So we're not going to get to that level of evidence that drug courts are at and that drug courts have. And I don't think mental health courts will ever get there. So I just wanted to point that out because I think it's an important thing to understand when making the decision of how to fund things and where to put the funding, because we're not going to be able to have a control group that is easy to go through. The research needed to do that would be monumental and staggering in its scope. And so I just wanted to put that out there very briefly before
Thank you.
recess.
Thank you. I actually did have that question in my mind as we're going through the testimony about that, so thank you. With that, I'm going to adjourn the meeting unless there's any other comments or questions. I know we all have a lot to think about here before the next meeting, and so with that, we are adjourned.